with an effort to discuss and deliberate upon matters that is concerning of your people. We ask your guidance, your wisdom, your understanding. We ask that we all listen to each other in an effort to the greater objective of making Jamaica a better place. We ask that you hasten the steps and protect those who are en route to this committee. We ask all these things through your blessed Son's name, Jesus. Amen.
Amen. Thank you very much, MP Sibbles. Apologies for absence. None save and except that Ministers Marsha Smith and Kamina Johnson Smith indicate they could be late. And first, let me welcome all members who are present. Just to bring you up to date, the Secretary has indicated and has given us a list, which I don't know if she has circulated, but it shows that we have 94 contacts or short presentations or even indicating their positions on the bill. So some of these persons we're not necessarily going to invite because they don't necessarily want to come. They just made comments, but to the extent that we will indicate that that we have received them and may read a bit from them. So it's 94. I'll ask the Secretary to circulate these short presentations or indications from these 94 members. Just to indicate further that because of the number of presentations and also because of our hope that we can complete hopefully in March, we're booked to return again next week, Tuesday. Next week, Tuesday is the 2nd, right? So we're going to be here next week, Tuesday again at 2 o'clock. And then the following week, the 10th at 2 o'clock. So the 2nd and the 10th of March, we're booked to continue the deliberations, or really mean the presentations. So the 2nd and the 10th, we will be. Now, I don't know if members have had a chance to read the minutes of the 5th, 13th, and 14th. Is there any likelihood that members have read them and would like to take them now? If not, we're going to put them off again. What's the position? Put them off? Okay, so we're going to put up the minutes of the 5th, 5, 13, and 14. But I can tell you that the Secretary has indicated that additional minutes will be forthcoming to you. So hopefully we can try and get rid of some of them, hopefully at the next meeting or two. So without further ado, we are going to...
So, Mr. Chairman, why are we putting them off?
Because apparently persons have not read them.
Okay.
So I'm going to urge members to read them so we can at least confirm them at the next meeting. Okay? I will remind persons to please try and read them so at least if there are any matters arising and the corrections to be made, that they can be made. Ms. McCullough, I think she's here. Right. And thank you, Ms. McCullough, for agreeing to return today. We know last time we had you late, so now we have you very early. So we'll ask you to start to make your presentations.
Thank you, Chair. Mr. Chair and other honorable members of this Joint Select Committee on the National Identification and Registration Act 2020, attendees, colleagues, Bank of Jamaica again expresses its gratitude for the opportunity to comment on the National Identification and Registration Bill, the NIRA. Our comments were provided on the 29th of January 2021 and covered a number of comments suggesting wording to improve the clarity of the bill. The concerns that were outlined in our comments on this bill primarily relate to One, the level of reliance that can be placed on the national identification card as conclusive evidence of the identity of an individual, the extent of cooperation that can be undertaken between the National Identification and Registration Authority, the authority, and third parties, such as, for example, a regulatory body such as BOJ. Two, the clarity of the intersection of the proposed NERA and the Data Protection Act, and three, other areas identified for clarification. In relation to the interaction of the framework under the NERA with customer identification verification obligations or requirements under the AML-CFT legislation, the issue is as follows. Under the POC and TP legislation, financial institutions are mandated to verify the identity of customers with whom they do business. Currently, addressing this obligation involves interacting with several databases where available. Given the following objectives reflected in the NERA at Clause 3C, E, F, and G, we raise the following matters to gain clarity on the way forward in addressing the applicability of the regime under the NERA to the verification of identification requirements in the AML-CFT legislation. Recall the objectives in NERA at Clause 3 speak to establishing a database to be known as the National Identification Databases, consisting of all identity information collected by the authority for enrolled individuals, provides for characteristics, assignment, and use of a unique national identification number to be assigned to each enrolled individual, to provide for the issue of a national identification card to each enrolled individual, and to prevent identity theft and other instances of fraud with respect to identity information. So the queries we have were, in relation to Clause 5, the National Identification and Registration Authority, Clause 5.3g on page 6. Will the authority be able to cooperate with other public bodies, such as the financial regulatory bodies like BOJ, to assist with confirming whether the identification of an enrolled individual has been verified? The issue did not, in our view, appear to be clarified by Clause 8, which states that in implementing the Act, the authority shall cooperate with other public bodies, or Clause 24, which prohibits the authority from disclosing identity information in circumstances other than those reflected in the clause, or Clause 25, which addresses the verification of identity information of an enrolled individual in the context of Clause 25.5, which stipulates that nothing in the preceding provisions authorizes the disclosure of identity information about an individual. 2. Will persons with AML-CFT obligations, such as financial institutions or designated non-financial institutions under the AML-CFT legislation, or employers who need to confirm or verify identification information, be able to access any information from the NERA regarding verification of an enrolled individual's identity? If so, what will be the mechanism to do so? Again, we thought that Clause 24 didn't provide the clarity being sought, and there is doubt on this being possible in the context of subclause 25.5, which stipulates that nothing in the preceding provisions authorizes the disclosure of identity information about an individual. Another issue that was raised in relation to identification arose in relation to Clause 19, content of national identification card, specifically Clause 19.2, page 25 of the bill. This subclause reflects that the card shall, in the absence of evidence to the contrary, be prima facie proof of the particulars which the card bears. Does this mean a person is not obliged to rely on the NIC, the National Identification Card, as proof of entity? Why is the caveat in the absence of evidence to the contrary included in the provision? Clause 25, requests for information or for authentication and verification services. We again flagged 25.5. We are not clear how 25.1 may be complied with without disclosure of identity information in the context of Clause 25.5, which stipulates that nothing in the preceding provisions authorizes the disclosure of identity information about an individual. Chair, we're just raising these queries because in implementing the framework under the AML-CFT legislation, when entities inquire as to how much reliance can be placed on the NIC, we need to be clear whether they will have to do other checks to verify the identity of an individual or whether there can be absolute reliance on the card as confirming the identity of the individual who presents the card. That kind of clarity will assist us when we are trying to provide guidance to entities on those obligations under the AML-CFT legislation. In relation to Clause 8, cooperation between the authority and public bodies. Clause 8.2, page 10. The parameters of cooperation that can be accommodated pursuant to this clause have not been reflected, and therefore the matters on which cooperation may be established are not clear. Clarity for us involves addressing the issue raised in relation to 5.3g of the bill, clarifying the matters that can be covered by the authority when cooperating with other public bodies, clarifying the kind of cooperation a public body would be expected to be providing to the authority, clarifying whether this cooperation is limited by any existing statutory confidentiality obligations to which other public bodies may be subject, extension of statutory indemnity or protections to other public bodies who cooperate with the authority. In relation to issues raised with the clarity of the intersection of the proposed NERA and the Data Protection Act, we raised Clause 27, pages 33 to 35 of the bill. The clause speaks to the duty of the inspectorate to examine the operations of the authority for compliance with the laws concerning the protection or confidentiality of identity information. The law that comes to mind is the Data Protection Act. The Information Commissioner under the Data Protection Act can also undertake activities to monitor or assess compliance with the DPA. So in reading Clause 27, we had some queries as to why include this activity of inspection as a function of the inspectorate under the NERA, that is, for monitoring for compliance with the DPA. How will the inspectorate interact with the Information Commissioner under the Data Protection Act, the DPA, in such circumstances, whose opinion takes precedence in the event of a divergence of opinion between the inspectorate and the Commissioner under the DPA on the authority's compliance or non-compliance with the DPA? These were some of the queries we had on reading the provision, and this informed the recommendation that was made in the submission at item number 45. The recommendation states as follows: for clarity, consider amending the provision to include wording that the inspectorate's duty to examine the operations of the authority for compliance with laws concerning the protection or confidentiality of identity information does not override or impact the jurisdiction of the Information Commissioner under the Data Protection Act. It was also felt that additional clarity is required to better understand the proposed scope for the tribunal, which seems confined to only hearing issues or concerns or challenges raised by data subjects or individuals interfacing with the authority or the database. If the inspectorate identifies an issue with how the authority is operating, why can't the inspectorate also refer an identification or non-compliance, an issue or non-compliance with the Act with the tribunal? It is noted that the inspectorate can report issues to third-party entities, but it seems the authority or the NERA should have an opportunity for perceived breaches or perceived instances of non-compliance to be addressed by the tribunal ahead of referral to persons such as the DPP. In relation to other areas identified for clarification and identified typos, the typos will be as outlined in the submission, so Chair, I wouldn't go through the typos. But in relation to other areas identified for clarification, we raised Clause 3, objects Clause 3G. It refers to the objective of preventing identity theft and other instances of fraud with respect to identity information. We recommend or suggest that this be revised to minimizing identity theft and other instances of fraud, as there is no guarantee that this legislation and the proposed framework can absolutely prevent these crimes from occurring. We know this is a drafting issue, so we'll be guided by the Parliamentary Council on it, but we just thought that perhaps we should temper our language in relation to preventing identity theft, etc. Clause 4, application. Clauses 4, 2, and 3, how a person's information is treated after that person opts out of the National Identification Register. We noted that subsection 2 implies that persons described therein are not eligible for inclusion in the National Identification Database. If that is correct, what information would such a person be entitled to receive, considering that there would have been no eligibility for inclusion in the database in the first place? And then the question arises as to how the law treats with an individual who becomes a person described in subclause 2, that is, he's no longer eligible for remaining in the database. How would one treat with that person's enrollment? Mm-hmm. And what happens to that person's information if that person opts out of the National Identification Register? In relation to Clause 5, the National Identification and Registration Authority, Clause 5.2, we queried what will happen will the Registrar General's Department continue to undertake the function of registering trusts? I should indicate, Chair, that some of the reactions to our comments were shared with BOJ, and so some of the responses received we noted. I think most of the typos were accepted, and in relation to this particular query, the point was made that this is an administrative function that is undertaken by the Deputy Keeper of Records, but I think more needs to be provided, perhaps not in the bill, but elsewhere, as to who will be undertaking that function. I know it's a Deputy Keeper of Records, but since it was at the Registrar General's office, I'm not sure if persons or the public will be clear that the function remains at the Deputy Keeper and that all else remains the same in relation to trust. So I think perhaps some more clarity on that regime would be useful. And then again, Chair, it's useful to us as well because, again, in looking at AML-CFT, we interface with all agencies, including persons who register trusts, and so that kind of clarity would also be useful for BOJ. Clause 5.3g, page 6, it is suggested that the subject of interagency cooperation is a separate and substantial subject that should be recognized as a separate function of the NERA. Currently, it is reflected in a very long sentence which refers to other functions of the authority, and we felt that the ability to cooperate was kind of lost in how that objective was worded, and we felt that there would be better clarity on the objective of cooperation if it was separately addressed. Hence the recommendation, Chair, that an additional subclause be included referring to the cooperation objectives of the NERA. Clause 6, Board of Management. At the last sitting of the committee, Chair, there was extensive discussion on this. Suffice to say, we'll just say that while the matter of policy seemed to fall within the remit of a board, for consideration is whether procedures would be for management. My takeaway from the last meeting was that this clause was going to be revisited, bearing in mind that the policy intent was that there would have been an executive board of management. So we look forward to seeing what changes, if any, come in relation to that. Mm-hmm. Clause 9, National Databases, General Observation. This clause should be reviewed to provide for stronger measures to ensure proper use of the information collected and for protection of such information. To be clear, Chair, when we say stronger measures, we mean stronger preventive measures to ensure proper use of the information. So what is it that is expected of the authority and to ensure that the information will be protected, properly protected when it is collected by that entity? And what measures will be in place for the protection of such information? We didn't see it in the bill. I'm not sure if it will be reflected anywhere else, but it would be useful for some wording to allow persons to feel assured that these matters are in fact being addressed. Clause 10, Enrollment. Clause 10.3b, page 14, consideration be given to deletion of the words insofar as it is reasonably possible for that identity information to be verified. Given the objective of the legislation and the contents of subclause A, our understanding is that the authority must not enter the identity information if it is not reasonably possible for that identity information to be verified, and so we felt that maybe those words could be removed. Section 10.4a1, page 15, please consider inserting the word legal before the word guardian. Rationale, in the Child Care and Protection Act at section 2.4, the term legal guardian is used to refer to a person who is not a parent of a child, who is recognized by a court of law as having the legal right to care and custody of the child and has all the powers of a parent. To be clear, the proposal is intended to ensure that the person who purports to submit an application for the minor to have a national identification number must have a legal right to do so. And this is to ensure that any adult, other than a biological parent, who is giving this consent on behalf of a minor to obtaining a form of identification should be recognized by a court of law as having the care and control of that minor. The objective of NIDS as providing a form of identification, it is recommended that greater scrutiny should be placed on persons who purport to act in the position of a guardian, and in so doing are filing an application for the NIN on behalf of a minor. We note as well that the term guardian is not defined in the bill, and perhaps consideration could be given to so doing. Clause 10(7)(c), we wondered whether it should be clear that this clause does not include renewals or replacements which are not considered to be a separate enrollment. So that we threw out as well, we asked the committee to consider. The rest of the issues raised in relation to Clause 10 are typos, and I won't go through those. Clause 11, identity information, 11(1)(a), we suggest that specific reference be made to the nearest relative or legal guardian of the person as part of the biographic data. I believe this may have been one that this suggestion was one that would have been given some consideration based on the comments that were the feedback provided to us, and the rationale we had indicated was the inclusion of the nearest relative or legal guardian may be relevant in the case of persons who are mentally disabled or wards of the state, particularly if the person does not know the names of his or her biological or adopted parents. Clause 11(1)(a), V or 5, page 17, we suggest that the provision be adjusted to read names of the mother and father, if known. Specific reference should also be made to the fact that the term mother and father should include adopted parents when adoption order is made pursuant to the Child Adoption Act, Section 9. And the rationale we had for that is set out in the submission. I don't think I need to read through that. Clause 11(1)(a) 7, page 17, it is suggested that, if applicable, be added to the wording in that provision. Clause 11(1)(b), page 17, it is suggested that appropriate language be inserted which permits the authority to create rules for alternate biometric data for persons who are physically disabled. A physically disabled person, Chair, may not have fingers or digits, etc. In such cases, alternative methods of biometric data, such as utilizing retina scan technology or voice recording or recognition, could be considered to be included as options. Clause section 11(1)(c), page 17, we ask that consideration be given to including the reference number of a birth certificate. We note that a significant portion of Jamaicans do not have an alternative form of national identification. That is, these persons may not have or do not have a form of photo ID which was issued by the government, but they would have their birth certificate, and so we ask that consideration be given to including this in the database. Clause 11(2), page 18, should the only option be to refuse enrollment where a person is incapable or unable to provide particular pieces of information? Should it be open to the authority to also request additional information that may satisfy the authority as to the individual's identity? We ask that consideration be given to that. Clause 12, verification of identity information. Clause 12(2), page 18. Notwithstanding the catch-all wording in Clause 12(2)(j), it is suggested that consideration be given to including a specific reference to other information contained in the civil status registers as a form of verification. As defined in the Registration, Births and Deaths Act, civil status registers include reference to births, baptisms, marriages, and deaths. For some persons, a certificate of baptism may be a useful reference, particularly for the elderly persons in rural communities. Clause 14, cancellation of enrollment, subclause 2, page 19. It is suggested that provision should indicate who will determine the accuracy of the record. From our reading of the provision, it seems the person who makes this determination is the authority. Therefore, the committee is asked to consider words proposing to amend the clause to specify that the information stored is determined by the authority to be inaccurate. Clause 14.5A1, page 20. Will the information be purged from the active records? If the information will be purged, considering that information might be of value if the individual should reappear or make an application for re-registration, how long after cancellation will that information be purged or destroyed? It is observed that Clause 33.2b speaks to regulations for the disposal of information collected in respect of an individual whose application for enrollment is refused. So the committee could clarify if that issue actually will go away once the relevant regulations are developed. What happens to the information on the death of an enrolled individual? Clarity on that would be useful as well, Chair. Clause 14.6, page 21, the period for notification of cancellation should be specified. In other words, is it immediate? Do you have a period of time within which to collect yourself before the registration of information is cancelled and the person is removed from the database? Clause 14.8, page 21, is a reference to Section 24 to this Act referring to the National Identification and Registration Act, or is it a reference to the DPA, Data Protection Act? In the feedback shared with us, Chair, it was clarified that this is a reference to the National Identification and Registration Act, but I wonder if it could possibly be made a little more clear by tweaking the language in that provision. Clause 14.5b, that's a typo, and that is as reflected in the submission, Chair.
The 5B, I'm trying to find it.
Page 20,
Judith,
Chair, 14.5b.
On page 21, there is a capital B. Which
so that capital B should be a common B and go back.
Yes, Chair.
Yeah, okay, good.
Clause 15, national identification number. After the death of an enrolled individual, will the national identification number be cancelled? It is noted that Clause 22 requires a national identification card to be surrendered. Clause 16, national identification card, 16.1. Read the issue of cards to each enrolled individual. To be addressed are children and persons with mental disorder, as referred to under subclause 10.4. We note that subclause 10.4, which treats with a similar subject matter, speaks to children and persons with mental disorder, but that language was not repeated in this provision, and we felt for clarity, consideration should be given to repeating the language to refer also to children and persons with mental disorder. And then there is the other rider. In other words, where the card pertains to an individual or person with a mental disorder, to whom will the card be issued? That information is also not set out in the provision, and it would be useful to have that kind of clarity in the law, Chair. Clause 16.8, should it be made clear here that the replacement card will be issued with the same number as the original card? It seems to be the case based on other provisions, for example, 15.2b and c. However, we're presuming this, and it would be good if it were clearly set out in the bill so one wouldn't have to be extrapolating if this is indeed the case. If the card has information stored with respect to individuals, are the original cards to be decommissioned? That kind of clarity would also be useful as well. We also queried, Chair, why it is an offense for not reporting a lost national identification card. So in other words, if I misplace or lose my card and I say, okay, I'll get to it next year, I am actually breaching the law, and I could actually be prosecuted based on this provision, and it felt a little bit harsh. And so we wondered whether there could be reconsideration of this, or at least maybe some explanation as to why this loss would be, and not reporting the loss of the card is an offense. Clause 16.11 refers to a typo as per the submission, Chair.
Is that correct, CPC? Look, see, that's
The typo, Chair?
Well, it's not so much a typo. The question is whether you should put all of that and shall be liable if it affects both A and B. You see CPC?
Reference was to the number in error in 19.1a, where the paragraphs were not numbered correctly.
No, but 11. 1611. 1611. 1611 A and B.
Yes, Chairman. It does appear that it should go back to the margin because the liability on conviction before the court would apply to A and B.
Yes, it's clearly not aligned when it was
Right,
printed.
so you're right, Ms. Macaulay. That should be revert to the margin.
Clause 18, period of validity of national identification card. Clause 18.4 reflects that the authority may require an individual seeking renewal of a national identification card to surrender the existing card in exchange for a renewed card. The question is, will the original cards be cancelled or decommissioned when a new card is issued? Clause 19, the only issue we had remaining was with a typo, as we already raised the issue in terms of the wording in Clause 19.2, which has, shall, in the absence of evidence to the contrary, be prima facie proof of the particulars which the card bears. We asked that query earlier on in the submission, and so we won't repeat that. 19.1a, Chair, is a typo. Numbering to be corrected, references to 1 and 2 have been duplicated instead of referring to 3 and 4.
Yes.
Clause 20, cancellation of national identification card. Subclause 4, in the absence of stating a fine here, subclause 28.1 would apply, which creates a maximum fine of $1 million. Given the nature of the offense and the risk of identity theft, would it be prudent to insert a specific penalty at subclause 24 of the bill, which is more commensurate with the egregious nature of the offense? Clause 23, use and security of information stored in the national database. It is suggested that a new subparagraph 5 be inserted, which imposes an obligation on the authority to create policies and procedures to minimize the risk of breaches of the Cybercrimes Act. This particular amendment would support subclause 9.8 of the bill and provide additional comfort to members of the public about the cyber risk management obligations imposed on the authority. Clause 24, disclosure of identity information. Subclause 5, this subclause should be clear which party is required to destroy the information. That is, whether or not that obligation falls on the party in receipt of the information from the authority. In our view, it would appear that the obligation falls on the party in receipt of the information, and so if that is so, then we would ask that the subclause be amended to state explicitly that this is the case and reflect that the Commissioner of Police then would have the obligation to destroy the identity information that was disclosed pursuant to the court order. Clause 24.6, we wondered whether consideration could be given to referring to all levels of appeal. I think in the feedback that was shared with me, it was not favorably considered, but for the completeness of records, I refer to it here. Clause 24.8, it is suggested that for clarity, the subclause should state who should give the certificate of destruction to the individual. Clause 24.9, page 30, in the second line, should this refer to subclause 6 as well as subclause 5? It seemed it should refer to both provisions. We'll be guided by the CPC on this. Clause 24.11, page 30. This provision presumes the individual will be made aware or become aware that the information has not been destroyed. However, the bill does not reflect any wording that suggests the individual will be notified that an application under subclause 10 has been granted. It is suggested that the bill should expressly require the Commissioner to notify the individual that 1, an application under subclause 10 has been granted, and 2, an application can be made to a judge or the court for the matter to be reviewed. Clause 25, requests for information or for authentication and verification services. It is suggested that the term accredited third party be defined. Clause 25.5 is, as we had indicated above, Chair. We are a little bit concerned about the wording there and the ability to verify information in the context of Clause 25.5. Clause 28, special provisions in respect of offenses. We had noted that the subsection appeared to be, the provision appeared to be incomplete. The concern really was that I think there was a dash at the end of subsection 1, and so it gave the view that there was more to come, but then it moved on into another subsection, so we weren't clear if that was the end of the thought or if more was intended for subsection 1. So that was the issue that was raised in relation to Clause 28.
You think there should be a full stop?
In our view, it should be a full stop if that's the end of the thought for subsection 1.
Okay.
Clause 29, powers of search warrant. Clause 29.3b. Given that Clause 29 addresses search warrants in relation to persons, a person is committing an offense under the NERO, why would the applicability of a warrant be excluded in the circumstances outlined at B? Which authority would make a determination that a circumstance at 3B exists, and at what point would this determination be made? We are of the view that this provision is unclear and should be revisited and, if possible, reworded for clarity. Clause 30, secrecy and confidentiality, subclause 2. Consider whether the penalty for breaching the disclosure obligation under this statute may be considered to be low in the circumstances. Under the BOJ Act, although the pecuniary penalty is the same amount, a custodial sentence is also possible. And those provisions in the BOJ Act that one could look at would be Section 34, capital D, subsection 2 of the BOJ Act, and Section 47.1 as well of the BOJ Act. Clause 30, subsection 1, this was a typo. Again, we ask that the word shall treat as secret, etc., under this act should be brought back to the margin and be followed by the rest of the clause. That was the issue that was a typo that was raised in relation to Clause 31, subsection 1. Clause 33, subclause 2. It is suggested that this subsection should also refer to the procedure for the destruction of identity information where enrollment of an individual is cancelled pursuant to Section 14 of the bill. Clause 36, the transitional provision, subclause 1. We note that a definition of the expression former department is stated in subclause 36.11. For good order, it is suggested this be included in the interpretation clause of the bill. Our comments, Chair, in relation to the schedules are all in relation to identified typos as outlined in the submission. Mm-hmm. And that concludes our presentation of our comments, Chair, in relation to this bill.
Yeah. Ms. McCall, I really want to thank you wholeheartedly on behalf of the committee. I think you have done an excellent job in perusing this bill. I mean, you have picked up things which, I mean, I'm sure many of us who have gone through the bill have not seen. So I want to thank you for the time you spent and the BOJ to bring these to the attention not only of the committee, but of the NID Secretariat and the CPC. So I don't know, Mr. Vernon, a number of issues have been raised, to my mind, of good, suggestions. And I would ask you to just respond as fulsomely as you can so that Ms. McCall and the BOJ can feel that, you have considered what I consider to be an outstanding contribution from the BOJ.
Okay,
is that okay, members?
Thank you, Chairman. Our legal officers will respond.
Okay.
Good afternoon, Chairman and members of the committee and colleagues. I will
and just to be sure, Ms. McCall, if in the clarity, if it is not satisfactory, please interrupt, okay? Go ahead, Ms. Faith.
Thank you, Chair. So through you, Chair, with regards to BOJ's submissions, going to just go chronologically through the bill. Number 3, objects. So with regard to clause 3G, we do agree that consideration may be given to replacing the word prevent with the word minimize as it relates to the objects. Clause 4, which is referring to the application of the act, with regard to the information that a person would be entitled to receive, considering there would have been no eligibility for inclusion. My apologies, I thought I had turned it off. The only thing the individual would be able to ascertain is that there is no identity information as it relates to him or her within the national identification databases.
Hold a second. Go ahead, Ms. CPC.
Chair, I just wanted to make a comment on the wording in 3G, because that wording tracks the provision in the Data Protection Act. So prevent was used deliberately in order to be consistent with the language in the Data Protection Act, where it creates an exception for those departments whose function might have as one of their functions the prevention of identity theft. So it's a cross-reference, so I suggest we keep the word prevent.
Prevent. Would it do no damage if we use minimize?
It would, because I'm suggesting that to create the necessary link with the provision in the Data Protection Act, the wording should be the same.
No, but if you remove prevent, what would you put there?
Chair, if you recall, the provision in 24, I think, of the Data Protection Act refers to, it creates a certain exception for processing for the entities who have as their function the prevention of identity theft.
Yes.
So to put minimize instead of prevent here would then call into question whether the authority is in fact an entity referred to in the Data Protection Act that has as its function the prevention of identity theft.
So you're suggesting we retain the words prevent? Okay.
Yes, Chair.
To point out that this is the objective of the act we're saying. Your objective is to prevent.
Even though you may not achieve 100%.
You may not achieve it, yes, but okay. That's a goal that you have.
Okay, AG, is that okay, Ms. McCullough? In other words, prevent, even though we know that we may not do it 100%, and that is why you had suggested minimize, but it would be inconsistent with the objective of total prevention.
I know the explanation, Chair. I might have used the words combating or some other thing because you do run the risk of never achieving your objective, but I will be guided.
Yes, it's the objective. Okay, thanks.
Just seeking a little clarification from the Secretariat. Give an example of what step would be taken to prevent identity theft. Because I do, while I appreciate why the word was initially used, objectives that are set should be objectives that can be reasonably achieved. So I also understand where the BOJ is coming from, but just give an example of what action would be taken to achieve that objective.
Okay, thank you. Chairman, may I?
Yes.
Okay, so to prevent identity theft, most of the cases re-identity theft now are concerning persons reusing birth certificates. So the steps that are being proposed is that you would tie someone's biometric to their birth certificate record, and by doing so, you are preventing identity theft.
The reuse of the birth certificate.
Yes, I understand, Chairman, the context coming from BOJ, that even though the objective is to prevent identity theft, and we are taking all of the necessary actions to prevent identity theft, there will always be risk because you have a human factor, meaning if you encounter any form of collaboration between the human factor, you may end up having identity theft for someone who is not in the database yet.
Okay.
Because you're only able to secure the birth certificate by attaching the biometric to it in the database in terms of data that you're storing. But
right.
persons who are not in the database yet, you can't guarantee that.
While we're at it, Ms. McCall had mentioned that the birth certificate should have some numbers, a specific number. Is there a proposal that once this act is in place, that birth certificate will automatically get a number which is relevant or consistent with the NIC?
Well, that is also a part of the design to have a unique identifier in all of the databases so that we can do the references. But a unique identifier by itself can't prevent identity theft.
No, I'm not saying that.
Okay.
She had said in her submission, one of the submission is that the birth certificate should have a number.
Yes, and we agree with that one, Chairman.
Okay.
Further on in our legal officer's presentation, we'll
agree
with
with
that.
that.
Yes, we agree with that.
Okay, sorry, go ahead, Ms. Facey.
Thank you, Chair. With regard to that particular suggestion that you just mentioned, Chair, I believe it was that the birth certificate number be included as one of the reference numbers, actually, not that we create a birth certificate number. Okay. And we had reached clause 4, and the query was, how will the law treat an individual who becomes a person described in subclause 2, and that is someone who is no longer eligible for enrollment? And our response to that was that the individual's enrollment will be cancelled on the basis of ineligibility. However, the individual may choose to re-enroll should they become eligible at a future point in time. The identity information collected will be retained in accordance with the provisions of the Data Protection Act as applicable for the period stated, and that will be within the applicable retention schedule in line with the data protection provisions.
And what happened to the number, the NIN?
Oh, the NIN will never be destroyed. The NIN will never be repeated. It is a single number applicable to one person for even after the person's death.
Right, so just to confirm, Ms. McCullough, once it has been assigned, it will not be repeated, it won't be cancelled. It's unique to that individual, and if the individual dies or disappears or migrates, the number remains. So it will not be reassigned or dies. Okay.
As it relates to clause 5.2, will the Registrar General's Department continue to undertake the function of registering trusts? Our short answer was yes, as at this time that is the policy. However, it must be noted that it is the Deputy Keeper who carries out this duty under the Record Office Act, and in that act, it is the Registrar General is not specifically mentioned. What occurs within that regime is that the Governor General appoints a fit and proper person. So at this time, there is no policy intent to change that. However, we cannot speak to what may take place over time.
Okay.
As it relates to clause 5.3g, with regard to the BOJ suggested or recommended that an additional subclause be included at 5.3g, which referred to the cooperation of objectives in the NERA. And we believe that clause 8 adequately covers this concern, as it states that the authority shall, in the exercise of its functions and in the implementation of the provisions of the Act, cooperate with other public bodies. And it further provides that each public body shall give to the authority such assistance as may be necessary for the proper discharge of the functions of the authority. And we believe that that is quite wide enough to include the what it is that BOJ is referring to here. Secondly, BOJ queried whether the NERA will be able to cooperate with other public bodies, such as financial regulatory bodies, like themselves, to assist with confirming whether the identification of an enrolled individual has been verified. That issue, in their opinion, is not clarified by Clause 8 or Clause 24 or Clause 25. And Clause 8 speaks to the cooperation. Clause 24 speaks to disclosure. Pardon me. And Clause 25 speaks to request for information or for authentication and verification.
Chairman, just to ask, are we going to have some deliberation on the explanations that are being given
Well, you
in
could.
response?
In other words, what the consideration, yes, members can interrupt at any time, sure. The point, AG, is that the BOJ has put forward a comprehensive assessment, and it's only fair that a response should be given to them. But that doesn't stop us from interrupting. So if you please.
How is the explanation and the suggestion being woven into the review of the particular clause? I'm just not so sure.
Well, if we accept, or if the NIDS team accept the recommendation.
If the NIDS team, Chairman?
No, just a second. What we're trying to do as best as possible, AG, what I'm trying to do is that they have had the opportunity to look at the contribution from the BOJ. So if they accept the contribution, they could make that recommendation to us. That's what we're saying. You get me? I mean, no, I'm not...
Be reminded the deliberations clause by clause is to be done by the committee.
Yes, and we will. So what I'm really saying is that at the moment, we're getting an opportunity for the NIDS team to respond on a point-by-point to the contribution.
If we would be retraversing the ground instead of taking it, opening it for a deliberation, if we go through that way, are we going to then go back over? I'm just asking what approach is in the best interest
and there's no doubt
of
that
time and substantially
and you know eventually when we get to the overall clause-by-clause assessment, we have a matrix, which we will eventually have. But at the moment, my view is that it's appropriate for the NIDS team to respond to the BOJ as we have with all contributions, so that at least an explanation is given to those who have made a contribution. I mean, you're saying that we should wait? Or is that your suggestion until we do the clause by clause and see what the suggestions are from the contributors? No, we could do that, but I just thought it would, out of a matter of courtesy, it was useful to respond to the contributors.
I'm wondering whether, in respect of submissions on various clauses, we would consider what is the intent and object of the clause, and whether what has been used sufficiently captures the words used, sufficiently captures and convey the intent, and whether the provisions can be improved upon.
Sure.
So, for example, I'm not so sure how we do that by a mere response to the provider of the comment. Perhaps if we collate
the suggestions.
So for example, the suggestion that the interagency cooperation be considered as a separate and substantial subject. And the response is that what is there has sufficiently covered it.
Okay.
Let us look at how cooperation across government has worked. You know, a major complaint about administrative difficulty in government is the silos that exist. And what it is that is so critical for there to be the kind of collaboration in achieving the aims of the NIDS across government. The agencies have been identified. I mean, are we providing for it in a way that will make it better going forward, knowing all of the issues that have repeatedly been raised about collaborating across government in getting information? Because the information, the identification system is going to the heart of something. And should, at the end of the day, make life easier. And people who are required by law or other processes to identify themselves. That requirement goes across government and it also goes outside of government. So
I just thought that in responding to the contributors, it assists us or enlightens us a bit more when we come to the clause-by-clause determination.
Matter for you, Chairman.
No, what do members think? I mean, we can leave it until we do the clause-by-clause deliberations, you know. But I just felt that we, you know, out of a matter of not only courtesy, but for our own enlightenment, if I might say so, that we just allow the NIDS team to respond, you know, briefly to.
Use of one word is also critical. So I don't find it insubstantial that a request to be made to consider another word, such as combat, minimize was the one suggested, as opposed to preventing, and whether reasonably, notwithstanding what has been provided for in the other piece of legislation, insofar as the retention of information, because the issue of identity fraud, identity theft and fraud is included, is part of the objective because of provisions relating to retention of critical information after someone has exited the database. So at some point, do you allow someone who has exited, if there is nothing to compare, to then re-enter the system as someone completely different? So, you know, the aim of the exercise, having gone through the process we have gone through with the attempt to legislate in this way, is really to ensure an integrity of the process and the legislation. And I don't know if merely having the very considered submissions just being put out and responded in almost a mechanic way is the best way of ensuring that clause by clause, where those submissions relate, are benefiting. But we can open it for the view of the committee.
No.
The committee is comprised of
there's no doubt that in the...
can share a view as to the approach that could...
No, believe me.
But let me just put on record that while the NIDS Secretariat undoubtedly plays a critical part of it, this is the legislative process for which the parliamentarians have primary responsibility.
Absolutely. So that is why I'm saying is that the parliamentarian, the members of the committee not only have an interest or should have an interest in looking at the contributions made by, say, BOJ in this instance, but what we're looking at is that at this stage, it is useful when you look at the nitty-gritty of the act itself for the NIDS Secretariat who have had a chance to examine the contributions and at least give an initial response. That is not to say we, the legislators, necessarily accept either side.
I will leave the matter to you in the interest of how the time is utilized, because I do believe that the recommendations that are not lightly made ought to not be lightly considered vis-a-vis the provision. But I will leave it in your capable hands.
Out of a matter of openness, we say, we respond, the NIDS team will respond to them. That doesn't mean that the NIDS team will tie us down and say that this is the law. It's because we are the ones who will determine. But, yeah. So, Ms. Facey, as quickly as possible, briefly, right? Go through it and a response to Ms. McCollum. So at least we appreciate that and know that the contribution she has made has been considered by the Secretariat, and which we will consider eventually when we get that matrix.
Very well, Chairman. As it relates to the cooperation with financial regulatory bodies, the NIDS team wanted to indicate that for the committee's consideration that as part of the financial institutions KYC process, the BOJ may wish to ask those financial institutions to request the consent of their customers to not only for the financial institution itself to request verification, but the regulator as well to request verification. And this may also be applied to other regulatory bodies as we go along. With regard to whether or not the employees, persons with AML/CFT obligations.
Hold on for me, please. So let's just look at the response. So the recommendation poses a question as to whether the NERO will be able to cooperate with other public bodies, such as financial regulatory bodies like the BOJ, to assist in confirming whether the identification of an enrolled individual has been verified. And the response is that it would be a matter for the financial institution as part of its Know Your Customer process to ask, whether the financial institution such as BOJ may wish to ask the consent of their customer for the regulator to request of NERO to confirm if the identity used to establish the relationship was verified. Please explain that for me.
What we understood from the question was that BOJ would basically be asking for the activities relating to a particular financial institution for each particular enrolled individual. And in order not to be disclosing information to an entity without the consent of the enrolled individual, because verification is with the consent, the BOJ would not have been able to obtain that consent. And consequently, we thought about at what point in time could this consent be obtained? And therefore, we said, okay, perhaps at the point of giving consent, you not only give consent to the financial institution to get the verification, but to BOJ or any other financial regulator to obtain activity information about your identity information.
Minister Hill Johnson.
Mr. Chairman, my recollection from another meeting at the Jamaica House office, a similar question was asked, but for a bank. I remember very clearly that the answer was that bank would have, I can't describe, I won't use the exact word, but would have a relationship with NERO to say, we are authorized to come to you to ask to verify. So Bank A will have how many millions of customers or hundreds of thousands of customers, and a new one comes in, and the person, I am the new person going to the bank, I present my new NIC and hand them the card. That says I am me because you have it there, but the bank wants to verify that this card is accurate and so on. They have an arrangement with NERO from what I understood, and they could just call, or whatever mechanism you use, online mechanism, to verify that. But that's not what I hear you saying about the BOJ. BOJ is the regulator of all these institutions. So why is it different, if it is different?
Because BOJ is not asking us to verify the identity information of the enrolled individual. BOJ is asking us to verify that each bank has actually requested the verification of each of their customers, because remember, BOJ has to ascertain that these particular financial institutions are actually doing what they're supposed to do, and that would be.
But shouldn't that be just simpler? I mean, if BOJ is asking if NCB or Sagicor Bank is authorized with you, that's a very simple answer. They either are or they're not, isn't it?
Is authorizing us?
If I understand what your response was to me, that the BOJ, which is the regulator of all these financial institutions, were to come to you and pick out institution X and say, is this institution authorized with you to verify cards? Isn't that a simple answer?
That's not what they're asking. They're asking us to confirm that the bank has actually done verification of an enrolled individual.
Yes, AG.
A clarification from the BOJ on this matter, please. Ms. McCullough, through you,
Ms.
Chairman.
McCullough, AG is asking, is that what you're understanding?
Yes, the Secretariat has interpreted correctly. So BOJ is not the person who is interfacing with the customer. So in terms of cooperation with the authority, it would be, one, to confirm what the verification mechanisms would be, two, whether verification is possible and has occurred, and that's the line of cooperation that we would be looking at from our perspective. And then we would also need to know what is expected of us if we are required to cooperate with the authority, because if you note, the clause does speak to the public bodies cooperating with the authority, but we're not clear on what that means. So that's the sort of clarity we're hoping to get. And in relation to banks, yes, we needed to know what is contemplated in the verification process, because if the card itself is not absolutely the identification of the person, in other words, once you have that card, you don't need to do anything else, that card is it, then what else would one have to do to verify that the person, the information reflected in the card is correct, and that it identifies the individual correctly?
Right. Minister Hill, your...
Just for clarification, let me try and simplify this. This is something I think I understand and do well. So the banks have your authority to check with you to verify an individual. Yes.
The banks have the individual's authority to verify, for us to verify, not our authority.
Yes, but you have to have an arrangement with the bank.
Yes.
So the bank has an arrangement with you to check with you to verify that I am me, because I handed them my NIC. Now, the regulator of banks, which is a higher level, wants to know that Bank A has verified me and is asking you. Well, that's simple. The regulator, which is built by the government who built you, is asking that Bank A has a right and has verified this person. That should be an easy question, easy answer.
It can't, because we're going into this possible disclosure of the enrolled individual's identity information.
Then this is the place to fix the law. This is the place to fix it. You're making that law. Fix it.
No,
because the Bank of Jamaica should have that right as the regulator to ask that question.
Assist me. Yeah.
No,
can you just point me to the provision? Just trying to locate the discussion in the provisions of the bill. So we have at clause 5.2D, develop policies, procedures, and protocols for the collection, processing, storage, authentication, and verification of information in the databases, consistent with the data protection best practices and in conformity with the Data Protection Act. And then over at clause 12, we have the provision for verification of identity information submitted by an individual for enrollment. Just assist me, please, in just pointing to the provisions that the concern would be situated in.
No, but with due respect, I mean, what the NIDS team is saying.
I'm a little confused, you know.
No, 1 second. BOJ would like to know whose identity has been verified. What the NIDS team is saying, it cannot do so under the NIDS Act. No. But if you do it for BOJ, why not for other government entities? Are we saying what's the
purpose of that inquiry?
I don't know. I don't know. No, but because bear in mind now, what the NIDS team would be saying, if someone inquires about a particular identification, say of me, then I must be told, according to the Act, that, say, a particular government entity has inquired about my information about me. Yes, Member Robinson.
I need some clarity. Right now, the Electoral Commission of Jamaica provides access to their database for banks to verify the identity of individuals. My understanding is what we're doing is similar to that, where a financial institution would have a link to the database, so when I show up with my national ID card, they can confirm that I'm Julian Robinson.
Right.
That's the only thing they're doing.
No, but
to confirm my identity so they can do business with me.
No, but bear in mind, Member Robinson, the answer is yes. If a financial entity asks for verification, that identity. What my understanding, Ms. Face is saying, if a third entity is asking whether a second entity has asked for my ID. In other words, what is happening is that...
Who is the third? Who would
BOJ. BOJ is
and why
asked
BOJ needs to know that?
To find out if Bank X has asked for my identity. That's the understanding I'm having. Is that so, Ms. Facey? And what she's saying is that BOJ can ask for my identity directly, one-on-one, but can't ask if the second entity, which is the bank, whichever bank, has actually asked for my identity. You see?
What I'm still not clear on, and maybe Ms. McCullough can tell me, why does BOJ need to know that specific information?
So to clarify, BOJ does not need that specific information. Recall, the issue is our ability to cooperate with the authority. So our interface with the authority is really going to be, has this entity been cross-checking data information with you? What do they do to cross-check with you? What are the mechanisms to get that done? It is in the process of regulating the entity. For the entity, they are the ones who do indeed need to be able to have some ability to verify the information from the database of the authority. Our interest in the matter is purely regulatory in terms of, is the entity doing what it needs to do? It does not need the specific individual's identification information, member.
Mr. Chairman.
Yes, Minister Williams.
Why couldn't the regulator then ask the entity to show it that it has done that, to demonstrate? Because I'm sure if you ask NERA for verification, there must be some record that you've asked for that. I don't know, just saying.
It could be done that way, but if one needed to do an objective check with the actual database holder, then that is how that objective check would be done. In the same way in which we interface with the FID, not to get specific information, but we get information on whether or not an entity is interfacing correctly with the FID and doing what they need to do to cross-check information that they have. So that it's purely regulatory and just to ensure that we are, in fact, monitoring the entities properly.
Yes, Senator Marley.
So for the avoidance of doubt, the function of the Bank of Jamaica in this regard is to ensure that the banks are complying with what they are required to do. That is correct. Clear.
Yes, that is correct.
It has nothing to do. The Bank of Jamaica is not interested in verifying the identity of any applicant, but simply to ensure that the persons that they regulate, the institutions which they regulate, are following the procedures which are required by the regulatory authority.
Is correct. Our interest from the BOJ perspective is simply to ensure that we can perform as a regulator, which means ensuring that they are doing what they need to do. And in order to do that, we have to be able to interface at that level with the authority to make us a better regulator and monitor of the entities and their obligations.
Member Robinson asked a question that I'd like to just go back to, as to why would the BOJ want this information? And I can see where, as a regulator, the BOJ gets a request from a country in Africa or one of our closer neighbors to say there has been a slew of transactions conducted by this person. They won't necessarily, that government or authority won't go to a local bank. They will go to the regulator of the banks, as would a central bank would go to a central bank, and they say this. Now, I'm asking, and this is really a question because this is what the JC is about. Given the particular responsibility of the Bank of Jamaica to regulate the financial institutions that the Bank of Jamaica Act requires them to regulate, shouldn't, and I'm asking now to the technicians and my colleagues, shouldn't the law be written in such a way that it could say that the regulator of financial institutions who are registered with whatever should have access to ask a particular question? I tell you why. Because in the initial asking, or it might very well be that the BOJ needs it for a local government institution. That government institution doesn't want to go directly to the financial institution because it could alert the very people they don't want to alert, for instance. Shouldn't the law allow the regulator to ask questions of particular individuals in a regulated institution? So it's defined in reference to the Bank of Jamaica Act. Shouldn't that be allowed, or that's totally ultra-virus for NERA?
So, Chair, we don't regulate to give specific information on individuals for anyone. In all of the language in our legislation, we are careful that cooperation is within the jurisdiction of cooperation. So it's in relation to entities. It is in relation to how they are complying with their obligations. It's in relation to what information we as regulators can share, etc. And in all of that language, it is always clear the specific information of individuals is not part of that arrangement. And that is because it has other implications, Chair, that BOJ and other regulators are not necessarily prepared to be responsible for. So if there is a criminal matter and someone writes the BOJ, we would get that request to the relevant authority, who is then placed to carry that request through its legal channels to ensure that the rights of the individual remain protected.
So in this instance, let me continue the example. The BOJ would then go to MOCA or FID or the JCF to carry that out if it was a criminal-related issue. Is that what you're saying?
Absolutely, absolutely.
Yeah. Okay, then, so go ahead, Senator Modlin.
I was asking, and to be clear, would it be that the BOJ would actually send a request to MOCA, or will the BOJ direct the inquiring entity to make a reference to MOCA? Because I want the clarity about the function of a regulatory body.
And we would indicate that they go directly to the MOCA. If they insist that we do it for them, we could do that, but the first response would be to direct them to the correct channels.
Yes, please.
So, Chairman, if I may, with regard, we now have reached to one of the areas where we can disclose to BOJ as an anti-fraud organization. If it is the reason that they request particular information is because of anti-fraud or in the interest of national security or prevention of identity theft, then certainly that information can be given. However, the question as stated was quite wide. It could just be a blanket request, which may very well require us giving out identity information of an enrolled individual who has not consented to this. And that was why it was answered in this manner. Now we are getting further clarification, and we can point BOJ to that particular clause.
Let me add a wrinkle for you. Suppose...
And that's clause 24.
Yes. Say we go back to BOJ as a regulator. Could they come to an arrangement with NERA to say, because we are a regulator, we should have the right to get this information on a particular individual? They would still be stopped from doing that under the way NERA is written now. Is that what you're saying?
It's not only NERA. Under the Data Protection Act, they would also be stopped under the entire data protection regime. However, as an anti-fraud organization, they're listed in the Data Protection Act as one of the anti-fraud organizations that disclosure can be made to in certain instances. And in this act, we actually do refer to that particular section of the Data Protection Act. So the regime already exists within the act. And this is one of the issues which would be going into the agreement. And that is why the authority is given the power to make these agreements, and it's not specified, it's not stated in a specific manner because it's something between the two entities. Right, so we have to cooperate, and the other entity has to cooperate under the law, under the tenets of the regimes.
So far, Mr. Chairman, yes, we're going on.
Mr. Chairman, can I just go back to the proposal just to hear briefly why the BOJ was suggesting that an object of the Act be for the cooperation in the cooperation, and not merely that it become ancillary to the carrying out of the function. Can I hear a little bit more about that?
Thank you for that question. So it really was a wonder. One of the objectives of the bill is to, as I say, prevent identity theft and do a host of other things. In order to effectively undertake those functions, cooperation is going to be key. But cooperation is blended in with a series of other thoughts in, is it 3? In 3,
looking just to say, why do you consider that the need for a separate provision as an object in order to achieve the goal, as opposed to how it's provided for at clause 8?
Right, so 53G AG, it says, as one of the functions, develop policies and protocols for the prevention of identity theft and other instances of fraud with respect to identity information, and cooperate with other anti-fraud organizations. But cooperation is pretty key in undertaking all of the obligations and objectives under this framework. So the thought was, why not have it on its own as against hitched into a thought process within 53G? It's just a matter of communicating the message as to what's really important and to really signal that the effectiveness of this framework hinges a lot on cooperation amongst the domestic authorities, really.
Ms. Facey, continue, please.
Thank you, Chairman. I don't know if perhaps, and I'm sorry to put her on the spot, I think this is now becoming a drafting issue somewhat. I don't know if
No, well, as I explained before, 3G it was worded in this way because that is what the Data Protection Act says. So that is why this language is used. It tracks it specifically for the purpose of linking it with the provision in the Data Protection Act.
Right. All right. No, so it's not a drafting point. Leave it as it is for the moment, okay? Mm-hmm. Continue, Ms. Facey.
Okay, thank you, Chair. Now, The Board of Management, we have already spoken to that. As it relates to clause 616, that collection, the word collection be inserted before the word custody. Currently, it reads, develop policies and procedures for the safe custody and where required disposal of all identity information, etc. And we believe that, yes, consideration may be given to the acceptance of this suggestion to specifically address collection, which is not necessarily addressed right there. And again, we refer to the draft.
CPC.
Well, again, this provision, 61A6, is speaking to the collection of information. So when safe custody is used there, it's already referring to the collection of information. So if one were to insert the word collection there, it would then read safe collection of information collected. That doesn't, it's not logically correct.
You don't support any change, right?
Thank you, CPC.
Noted, Ms. McCullough?
Yes, Chair. The drafting issues, I will be guided by CPC. As I said, if it's not readily apparent to us, that's why it was raised.
Of course,
so
sure.
I think we just want to make sure that even if it's apparent to you, it needs to be apparent to persons who are going to use it.
Okay, thanks. Ms. Facey.
Right. I believe we've looked at clause 8. National databases. There's a general observation that this clause should be reviewed to provide for stronger measures. And we are just requesting some clarification as to the specific concern. We're not certain what is the weakness that you are seeing there and what kind of stronger measures should be stated here. So if you could, and then we could respond.
Through you, Chair. So the stronger measures really meant preventive measures. In other words, given the responsibility the authority has and the kind of information that it's going to be responsible for, it would be useful if the legislation actually, whether in the primary statute or in regulations, outlined some of the safeguards and measures that the authority would be engaging in and to ensure that the data will be secured, that there are appropriate safeguards in there.
You don't think that the language is comprehensive enough to ensure that that is done?
Which is why we raised it, Chair. We thought maybe it could be a little more clear in terms of preventive measures. So preventive measures looks at what the authority should have in place administratively, including in it whether it's record keeping, persons hired, measures applied through IT, whatever else, things that should be in place to ensure that it is appropriately covered.
Through you, Chair.
It's something to note,
Well,
for the
Chair,
consideration of the committee later on. The question is whether stronger language should be used to ensure proper protection of the information collected. Yes, Ms. Facey.
Sir, just to point us, the committee and my colleagues to clause 23, which is under part 4, use and security of information stored in the national databases. And in that particular clause, the authority is mandated to keep the information stored in the national databases in a secure manner and to preserve the confidentiality of the information. And that clause indicates several actions that the authority must take. I don't know if those...
So, Ms. McCullough, read 9 in collaboration with 23, okay? All right, go ahead, Ms. Facey.
With regard to the enrollment clauses, the enrollment clause in 10.3b, the BOJ is asking why the words, insofar as it is reasonably possible for the identity information to be verified, is necessary, and given the objectives of the legislation they indicated, their understanding is that the authority must enter the information once it isn't reasonably possible for the information to be verified. Our thoughts on that was that the inclusion of the phrase is actually necessary to preserve this discretion. and the use of that discretion by the authority in determining that information is actually sufficient to meet the verification purposes. However, again, reference is made to the CPC. Reference is made to the CPC as the final arbiter on...
CPC, any suggestion?
I don't have any particular objection. To me, it's just a matter of policy whether you need this additional cushion here.
The secretary will note it for... Yes, Ms. Wilkie.
Minister, it's there because there is an acknowledgement that it may not be possible in a situation to verify the information that's given. So it's giving the authority the discretion. After all efforts to verify the information have been taken, those measures not having been successful, it is not possible to verify the information received. So that is why that is there. So far it is reasonably possible for the identity information to be verified.
So it's a sort of catch-all phrase?
That's the intention.
Okay.
Just to consider those extreme situations.
Understand, Ms. McCullough? In other words, it's a sort of residual phrase, just as the Ms. Wilkins has said, in the event that you have tried everything. Okay?
Sure, Chair, no problem with that. I don't mind catch-alls.
Okay, good. That's a catch-all phrase.
What clause is that, Chairman?
This is clause 10(3)(b), where it says BOJ was suggesting deletion insofar as is reasonably possible. The deletion of that phrase. BOJ is asking for the term guardian to be defined. Is that necessary, CPC? I mean, is a guardian defined in the...
Well, I agree with the response from the technical team. I think they had written in their matrix that this term is necessary to ensure that the children with de facto guardians are not excluded from the NIDS.
Sorry, what was...
May I just ask a question, Chairman, just going back to...
Sure.
So, what kind of information do you foresee being entered into the National Identification Database that could not reasonably, possibly be verifiable?
An address, for example, parental connections, just information that you have submitted that the authority would be barred from including because they had not been able to verify that information. So let's say to verify the information, they would have had to communicate with another country, go through extreme measures, and it just is not possible in that situation. Because there's a range of things that happen in human affairs.
Because you might want the place or date of birth of your grandfather or your father. And your father may not be known.
In Australia, and it's just...
No, your father may not be known.
And that too.
Yeah.
That too, sir.
Yes.
Yeah.
So that is a sort of information. What did we say about legal guardian? Sorry, is it needed?
It's in the response provided by the NIDS legal team.
Right.
The term guardian was used to ensure that the children with de facto guardians are not excluded from the NIDS, as opposed to the term legal guardian, which is used in a different context in the Child Care and Protection Act. I think the contexts are different.
So there's no need for the addition?
To add the term legal.
Okay. All right, thanks. Continue, Ms. Facey.
Thank you, Chair. Should it be made, this is with regard to 10.7c, whether or not it should be made clear that this subclause doesn't include renewals or replacements, which are not considered to be a separate enrollment. And our response to that is that renewal and replacement do not constitute enrollment, and accordingly, the individual would not be in breach of this particular clause. With regard to Clause 11, the BOJ suggesting that the specific reference be made to a nearest relative or a legal guardian to ensure that persons who are not who are mentally disabled, persons who don't know the names of their biological or adopted parents would be still included in the NIDS. And we are of the opinion that consideration may be given to the expansion of persons applying on behalf of others to include the nearest relative, their guardian, or the next friend in this particular context.
Okay.
In clause 11(1)(a)(5), BOJ suggesting that the words, if known, be inserted after the names of the mother and father. And we don't believe that this is necessary because the information as stated in the birth certificate will be what will be utilized. So the identity information that's listed in 11(1) is required for enrolling the individual. However, the information is not mandatory, so we don't believe it's necessary to put in additional words.
Okay, very well. Is that you notice we're responding to your well sought out contribution, Ms. McConnell?
I know, Chair, you're going a little fast, so I've just asterisked where I thought maybe more clarity would be useful for the purposes of end users of the bill, but I'm mindful of the time, so I'm just sitting quietly and listening, Chair.
Go ahead.
With regard to clause 11(1)(a)(7), the words, it's applicable, the BOJ suggested that be added. And we again don't believe that this insertion is necessary because the information being spoken to is not mandatory. And therefore, the person would not be, in breach of anything or would not be providing insufficient information. Clause 11(1)(b), the BOJ...
Ms. Facey, just to say though, the fact that information may not be mandatory doesn't mean that where it is requested, it can't state that if it applies, just by way of example. So, I mean, I appreciate the response, but it doesn't mean that it may not be applicable. It may be requested that you provide your place of residence and any other place, principal place and primary place, but that may or may not apply. So there is no harm just in considering response.
Okay, very well, AG. Thank you for that.
Okay, good.
Clause 11(1)(b), the BOJ is suggesting that appropriate language be inserted to permit the authority to create rules for alternate biometric data for persons who are physically disabled, because a physically disabled person may not have fingers, and consequently, they are suggesting alternative methods of biometric data, such as retina scan technology or voice recording or recognition could be considered. And the response to that is, in light of the Constitutional Court's ruling, the fingerprint and the facial image were considered to be proportionate to the intended use of the identity information. And that is why those were the only pieces of biometric information included.
But certainly. So what biometric information would you take for someone who has opted in where those enumerated are not possible? Just think about the suggestion.
Right, so fingerprint.
If you go to subclause 2, subclause 2 is general, and it is to deal with a situation where an individual is unable to supply any of the information that is requested. The authority has the determination to make as to whether the sufficiency of it and how it would proceed.
Sorry, AG, that's okay? All right, continue.
It may be also important to note that the Fingerprints Act does not only refer to an actual fingerprint, but to other pieces of biometric information.
Okay.
And this is fingerprints pursuant to that act. Right, and this is the one we had spoken of earlier, Chair, to consider including the reference number of a birth certificate, and we believe that consideration may be given by the committee to include this reference number. Should the only option be to refuse enrollment at subclause 11.2, should it be open to the authority to also request additional information? And we are of the opinion that the listed information is sufficient to determine the individual's identity for the purposes of the needs and also for KYC requirements. And most importantly, it's in accordance with the principles that were laid down in the Constitutional Court's ruling. And that is why it is inserted in that manner.
Okay.
12.2.
11.2. Where are you?
12.2.
Oh, sorry, go ahead.
Yes,
sorry.
we finished with 11. 12.2, there is a suggestion by the BOJ because the definition of civil status registers in the Registration Births and Deaths Act include reference to births, baptisms, marriage, and deaths, that a certificate of baptism may be a useful reference, particularly for elderly persons in rural communities. And the response to that is that the birth registration is the first official and permanent recording of a person's identity. Therefore, the proof of registration of birth is the birth certificate, and then all other civil registration documents come out of that particular. It's a breeder document. And therefore, the birth has to be established prior to the registration for any other document, including a baptismal certificate. So it would be unwise to register any other life event. Pardon me.
Yeah, go ahead, continue.
Right. It would be unwise to register other life events until the birth registration has been established. But importantly as well, the catch-all phrase which BOJ had indicated is there, and we believe that that is sufficient to include. With regard to cancellation of enrollment at 14.2, it is the BOJ suggesting that the provision should indicate who will determine the accuracy of the record. Should the clause therefore specify that the information stored is determined by the authority to be inaccurate? And we believe a reasonable inference may be drawn from the clause subject to the CPC's indication that it is indeed the authority who will be indicating whether or not the information is accurate.
BOJ suggested it could be clarified. I mean, naturally it's the authority who would do it, but is that clear from the draft? CPC, have a look at it again, okay? I mean.
Yes, Chair.
Clause 14.5A1 refers to the purging of information in certain circumstances, and BOJ wanted to know if the information will be purged from active records, and our short answer is yes, it will be purged from active records. If the information will be purged, considering that information might be of value if the individual should reappear or make an application for re-enrollment, how long after cancellation will the information be destroyed? Our response is that the enrolled individual does indeed have the option to appeal the authority's decision. And if the time for appeal has elapsed, it's only after the time for appeal has elapsed without an appeal being brought, or if it was brought and it's unsuccessful, and that's indicated at clause 14.5.1, that any action will be taken to purge the information. With regard to persons who are not eligible, to protect the integrity of the system as well as the previously enrolled person's identity, consideration may be given by the committee to permit the retention of minimal identity information. And what happens to the information when someone dies, when an enrolled individual dies? And we believe that consideration may also be given by the committee to speak specifically to this particular circumstance in the bill, subject, of course, to the CPC.
But my understanding, Mr. Vernon, is when a person dies, the number is retired. Obviously, the NIN number is retired. The question is, what happened to the information? Is it archived? Obviously, it's not active any longer. Or would it be active? I mean, if the person dies, I mean, would it be still in the active database that someone, the bank can call you to say, and you will say the person has died? Or how would, I mean, that is what BOJ is asking. What happened when a person dies? What happened to the information that is in your system? What would be in the system?
I think, Chairman, the answer to the question is somewhere between the legal provision and technical, but technically you would seal the information, but the question here is, what is it that the bill is empowering us to do? I think that is what Kanika is trying to...
You see, members, the question is an interesting point, because I don't necessarily think that the information should be removed from the database, because there might be persons who, it's important that at least in the database it is shown that the person has died, maybe, but you don't know later on if somebody wants to check on this person's information to say that the person has died. To give a good example, the Pension Act. I mean, the Accountant General might want to know if this person is still alive. Yes, Senator Hill.
Minister, Chairman, we need to remember what this product is called. It's called a unique identification system. It's not an identification system. We have a whole heap of them. This is called unique. And the only way you can make it unique by definition is that it can never be repeated. Well, it can never be repeated if you have a record of it and somebody dies. Otherwise, people have been known to go to the cemeteries and get voting record created.
Yeah.
Among other things. So for it, we must not forget what this particular product is. It's a unique identification, and unique means it can only be one. And if that's the case, it's like the passport. When I finish my passport, and I finish a couple like many of us have, PICA or whatever it was that its predecessor was, they have that information.
No, but Minister Hill, that's not the question, The unique identification number can't be repeated. I mean, it may be out of the system because it has been assigned to a person. But the information about the person, is it retained in the active database?
I understand that, but I'm saying by the fact that you have a unique number attached to that information, they have to remain linked. You can't, if you put the number, if you keep the number alone, and you need to check...
No. The answer is yes. But the question is whether...
my answer is yes.
Is there a process where you archive the information?
My answer is yes, you have, because you shouldn't de-link the number from the information.
Right, yes, Senator.
What about the relationship which is going to exist with the registrar of the Registrar General?
No.
Yeah, I'm going to come to it, because of course, you would have to have the notification that the person has died. Even if it is retained in the active, that would come up, that there is a death certificate attached. But Chair, what I wanted to really suggest, that we look at how we treated with it in the Data Protection Act, and then when we come to the deliberations, we might be able to extrapolate that information as a guide.
Yeah. All right. This is something for consideration later on. Okay, Ms. Facey, go ahead.
I just wanted to note that it is important for the prevention of identity theft for the information to be kept out of the active information, but kept by the authority, because you run the risk many decades from now of someone unlawfully using the information of a deceased individual and presenting it as their own and enrolling in the database, and by so doing legitimize a false identity.
Understood. Continue, Ms. Facey.
the question. So the issue is, how should the identity information of an enrolled person who has died be treated by the NERO, bearing in mind that, that the authority has responsibility for registration of births and deaths?
Right. No, it's an interesting point. What do we do with it?
Right, so I'm just saying, let us note the
Very
question, because
important point,
it's an
yes.
issue that would have to
You'd
be...
agree that that law does not provide for the removal of that information from the civil registry?
Well, again, let us consider it. Okay. Let us consider it
later on,
having regard to
it's an important
the functions of the NERO.
Absolutely, because that information cannot die. The question is, where does it go? Right. Yes.
But Chair, Clause 33(2)(k) also provides for regulations dealing with the procedure for archiving information in the custody of the authorities. So I think that it's envisaged that it would be dealt with there. 33(2)(k).
Okay, fine. No, so that is for consideration, AG.
The answer preliminarily is that such information is to be archived.
Quiet.
Then regulations would have to be promulgated in respect of the process for so doing and the integrity of the archive.
Absolutely. Thanks, CPC and AG. Okay, Ms. Facey, go ahead.
The BOJ also wished to know the period for notification of cancellation. They indicated that it was their opinion that that should be specified. And our response to that is that if indeed it needs to be specified, we would provide for that in regulations. We would not wish to insert that in the principal legislation.
Okay.
Additionally, with regard to 14.8b1, I believe Ms. McCullough had spoken to this already, but this is indeed a drafting question as to whether or not it's necessary to specify that section 24 that's spoken to in that particular subclause refers to this act or to the Data Protection Act.
No problem.
Clause 16.1, with regard to the issue of cards to each enrolled individual to be addressed, are the...
Yeah, we dealt with that.
Sorry, sir. Okay. Sorry, Chair. Could you repeat what you just said?
No. Well, obviously, when the person dies, you're talking about clause 15.
No, Chair. 16.1. Oh, I'm so sorry. I skipped that one. Thank you, Chair. So after the death of an enrolled individual, will the name be cancelled? And it is noted that clause 22 requires that the NIC be surrendered.
Right.
And our response is clause 15(2)(b) and C indicate...
No, but just to note that the name won't be cancelled.
Right, sir.
Right, okay.
And that is where it is specified in
Right.
15(2)(b) and C, that it will never be cancelled and will survive the death of an enrolled individual.
Right.
Clause 16.1 speaks to the issue of the actual issuing of the cards. So
just remind me, the responsibility to surrender the NIC is placed on whom? On the death of an enrolled person?
It goes back to the authority.
Representative.
Yes, but who has the responsibility to place it back to the authority? We know how estates are managed. They're personal representatives, executors, or administrators, etc. Just asking to be reminded. How is it provided for?
Who has the responsibility to return it on the death of an individual, Mr. Vernon? Who does?
Sir, we're currently checking to see whether it was provided for. We crave your indulgence on that point. But certainly, for example, in relation to the JPs, when they die, their personal representative has to return the seal to the
That is correct.
So that's a framework that we
that
can
you could look at in the regulations.
Yes, if it's not.
Very important you look at that because it's not provided for to the best of my knowledge in the Act. So that has to be returned, okay? All right, continue.
All right, sir, with regard to 16, right, so back to 16.1. This is speaking to the issuing of the physical card to each enrolled individual. What if what about children and persons with mental disorders who may have someone else apply on their behalf? I believe, well, we had indicated initially that clarification was required. However, in their presentation, clarification was indeed given by the BOJ, who suggested that language should be repeated, and we believe that that may be given consideration by the committee subject to the drafter.
Okay, it's a point to note. CPC, I mean, so this is a point to note, right? We'll, good.
Oh, right. So to speak to the AG's question earlier, in clause 22, the obligation to surrender the national identification card, the individual must surrender that card to an authority, anybody, an individual, where it was issued in respect of an individual who has died and over whose affairs the first mentioned individual has charged, whether or not they're a personal representative.
Okay.
And that's on page 27. So
okay.
Yes. Okay, so, right. So we had referred to this. What do you think? Oh, okay. So in 16.1, when we spoke to the application on behalf of someone, of a child, of a minor, or someone with a mental disorder, it specifically indicated that it had particular words in there. Let me go back to it. Right, so it states that where the application is made on behalf of someone, the information required to be provided shall be treated as having been provided to the individual if it is provided to the applicant. However, in this particular clause, it doesn't repeat those words, so BOJ was wondering if it was necessary to do so.
Oh, no, because the provisions are read as a whole, so because it's provided already for in the previous provision, there's no need to repeat it again in another provision.
Okay. Okay, Ms. McCullough. All right.
Thank you, CPC.
Continue.
Right, so clause 16.8, should it be made clear here that a replacement card will be issued with the same number as the original card? If the card has information stored with respect to individuals, are the original cards to be decommissioned? And we repeat that it's not necessary because the name remains unchanged. So the only thing, if you will recall the section that speaks to what is on the card, it indicates that there's a card control number. And that is with any identification card or any access card, you'll know there's always a number, and it's to control for security purposes, and that's the only number that will be changed on a card as it relates to, and that's if a physically new.
Okay, proceed.
Okay. The original card will no longer be valid once it, and that's why we require it to be surrendered for security purposes as well. Clause 16.11, oh no. Right, so clause 16.12, why is it, BOJ is not clear why reporting a lost national identification card is an offense. And our response to that is that, or the policy behind that is that it's to guard against the security risks of having that card out there, and it's to be a deterrent. So it's similar to a passport, where you come into possession of a passport because this document can be utilized maybe to commit identity fraud. And one of the objects is the prevention of identity fraud. And consequently, it was made an offense to be a deterrent.
Is that clear, Ms. McCullough? The whole idea is that you don't want that card, if it is lost, to be used.
Yes.
That is, if it can be used.
Yes, I'm clear on that intent. I'm concerned about individuals who are not necessarily the best in terms of being meticulous about their affairs. So that is certainly something that would have to be clearly communicated, because you don't want a whole plethora of citizens suddenly becoming criminals by virtue of this particular provision. But I'm clear on the objective, Chair.
Yes. Okay, go ahead.
May I ask, Chair, through you, if Ms. McCullough, not putting you on the spot, but have you considered any other manner in which we could treat with this situation then?
If, for instance, a person is registered and they try to do a transaction and they use alternative information and the database suggests that there is one of these, they could do a cross-check, and if the person can't answer as to where the card is, perhaps at that point in time the issue could be resolved in them indicating, and then the database is corrected or some other measure like that. If it's the only identification that they're relying on, then they would definitely have an issue in trying to conduct a transaction, because they wouldn't be able to rely on anything to conduct the transaction. So that would be motivation for them as well. So I was just wondering if consideration had been given to non-criminal persuasive mechanisms before one came to the conclusion that it should be an offense. Chair.
Well, it's a regulatory offense, rather than a strict criminal offense. But, I mean, to say make it a civil offense is really what it is. It's somewhat like a quasi-criminal offense. Okay? Okay, continue, Ms. Facey.
Okay. With regard to Clause 18, the BOJ wanted to know whether or not the original card would be decommissioned or cancelled. Yes, it will. With regard to Clause 19, the subclause reflects that the NIC shall, in the absence of evidence to the contrary, be prima facie proof of the particulars which the card bears. And BOJ's query was whether this means a person is not obliged to rely on the NIC as the proof of identity. And yes, indeed, the person is not obliged to, an enrolled individual is not obliged to utilize it, because this is a voluntary system, and the enrolled individual will decide whether or not to use this identification or another document at any point in time.
Okay.
Right. With regard
Chair, may I?
Yes.
The answer to that query presumes the person at issue is the person relying on the ID. What about the person who is supposed to be accepting the card as identification? So the financial institution or the other person who accepts, you tender this document as your identity, as evidence of your identity, as your identification. Would that wording fuel an action that suggests that they would not be willing, they wouldn't rely on it or shouldn't rely on it? I'm just wondering behind the policy, behind the words. And this is only to seek clarity so that we can help ourselves when we are also helping with the enforcement.
Okay, so you're speaking more about why is the caveat in the absence of evidence to the contrary there?
As I understand it, the card itself, especially for government agencies, the government agencies would accept it as proof of their identity. Whether a private entity does, one would hope persuasively they would, but I don't get the feeling that you could tell every private institution that you must accept it. What's your view on that, Mr. Vernon?
Just before the answer, I think at the heart of the issue raised, for persons who have opted in the system, for whom a NIC has been issued, and there are no issue with the authenticity of the information verification, what it is that the person who possesses the card hopes to get from having it, and those to whom it is presented. How is life made easier?
What's the last point?
How is life made easier for someone who has opted into the system and presents the NIC as proof of their identity, where there are no issues in questioning whether it is authentic or whether the information has been verified? How really is someone's life made easier who is required to identify themselves for any of many reasons?
I think Mr. Vernon can respond at length, but just give one or two examples, please.
when you consider, maybe we need to look at it in terms of the benefits, because what we're proposing to issue is a digital identity, which is different from all of the cards that are now being issued by government. Card that has digital certificates to facilitate the use of digital signature. It's also a card that would be a one-stop shop to verify not only the individual identity, but also the address, and to use the card to authenticate, meaning you can use it to sign into a service. So having said that, the benefits then would be that the card holder will be able to consume more digital services behind an electronic device.
Especially if you have digital currency, right? But I think, AG, a good example, as I understand it from the PICA, a good example is where you could use the card to get your driver's license or passport easier without having to go through the process of, say, getting another birth certificate or getting your photograph verified by, as they now do, by an attorney or a GP or a minister of religion. So the benefit would be you will be able to use it and overcome some of what the requirements to, say, get a passport. Okay?
Provided for, Chairman?
No, this is an administrative position. Right, because the government agencies would, because of this clause, government agencies would see it as a prima facie evidence of your identity. So for you to need to get a passport form verified by a GP or an attorney at law that this is so-and-so, you use the NIDS card as the verification. Okay? I think that's my understanding. All right, continue, Ms. Facey.
Right, Ms. McCullough was speaking again to why the caveat in the absence of evidence to the contrary was utilized. And our response is that the document is prima facie proof, but it's rebuttable by the provision of other evidence to the contrary. So if it's, once you present the card, it's because of the trust that should repose in the system, you should be able to, the receiving party should be assured that this is in fact your photograph, this is in fact your date of birth, this is in fact your card, and all the information thereon does apply to you. And you will not be required to be filling out forms endlessly or presenting any other sort of information, because the third-party entity will be able to go back to the needs and verify all of that information.
No, but her point is well taken. Why are we using that phrase? If it is a fulsome evidence of your identity, why are you saying, putting in that caveat in the absence of evidence to the contrary? The only evidence could be that it looked like a fraudulent card, right? But what else could there be? Any idea, Mr. Vernon? I mean, what, in the absence of evidence to the contrary, that was BOJ saying, why do we have that phrase at all? Yes, Mr.
Minister, it's usually expressed this way.
No, you turn on your mic,
Oh, it's on, but it's not coming on. Okay. It's on. It's on. Okay. It's a little temperamental. Yeah, it's expressed this way in the other laws that we looked at. That caveat is present in more than one other law that provides for a public document being, on the face of it, the information that's there being prima facie proof of that information.
No, but in this case, so much effort has been shown to make this card a unique identification card. The question that BOJ is asking, why have that?
Well, let us say that this is a matter before the court, and where the Evidence Act would would, if followed, indicate that you're not supposed to look beyond the information that's on the face of this card. It is to be accepted as valid information. But what if evidence is presented to the court, however, to show that I used some fraudulent means to produce this card? Then it would be evidence to the contrary.
No, but then that would be covered by a different section. What you're really saying is that what BOJ is saying, if you have this card, when you use that phrase, you are suggesting that there could be some possibility that the card is not valid.
May I just ask a question a little differently? So you may have conclusive proof of evidence or prima facie. Where prima facie is used, it's usually an indication that it's on the face of it, but below it. So what are the words in the absence of evidence to the contrary intended to convey that prima facie proof does not sufficiently convey? Mm-hmm. In the context of substantive law, conclusive versus prima facie. Rebuttable presumption as opposed to, I'm just asking, because I think.
That's applying the definition as taken in law, but as a matter of strict interpretation, it's a dictionary definition that one would go by, which includes just on first impression. So without these extra words, it could be interpreted that way. So I think it's just extra belt and braces. Right.
So what I think AGN is saying is that from you say prima facie, you don't need any absence to the contrary. No, I think BOJ has a good point there. Something we should look at, because from you say, it's a different matter, you know, if you had said it's conclusive proof.
Really no harm is done, because the entire scheme of the law does allow for verification of what is provided and a mechanism, you know, for that. So.
Okay, the answer, Ms. McCullough, is that the phrase looks superfluous, if I may say that.
You know, Chair, I really would implore the committee to revisit that, because it throws you, it really throws you when you want to stand behind it and say there's nothing more to look at. When somebody asks me, what does that mean? I might begin to fumble to explain why that is there, when you should be able to rely on this thing as prima facie evidence. So I really...
Yes, I think that's a very good point, and we need to just, if this is going to be the card, we can't leave it that there's even the slight possibility, which we can't identify, that could impeach the card. So,
I've been wondering, and just remind me, where and whether the treatment of the card as a matter of policy. You know, this is part of it. It's prima facie proof of your identity.
Right.
Hello. Should it set out at a minimum for those who have opted in and those who would receive the card, how life would be made easier in transaction? I'm just wondering where is to be set out. So just remind me where and at what stage those who are being enticed to opt in and those who actually opt in will know the full benefits. Where will that be set out? Those be set out? Short answer, no.
Well, the use of the card section does indicate what you can do with the card, but not social benefits. I don't think we would legislate something like, I'm not understanding.
Social benefits, utility.
Okay. Sure, go ahead, Mr. Vernon.
Take, for example, AG, the Nigerian National Identification Law. They outlined in regulations all of the different things that you can use the card for. So maybe this is something that could be considered by, by policymakers in terms of outlining in regulations all of the different utilities, so persons know clearly.
By whom?
Well, something that could be considered by
we the policymakers.
Yes, yes.
Okay, something we need to look at, right? Okay, see if we can finish up quicker, Ms. Facey. Sorry? Well, this is, it's, yeah, please.
All right, sir. With regard to Clause 20, Part 4, in the absence of essentially, the offense created in this clause would only create a maximum fine of $1 million, and in fact, the fine is located elsewhere. It's not within this particular clause. It's located in the general offense clause.
And it is something we need to look at, okay? Mm-hmm. Okay. So please, we make a note of that, Secretary, in terms of this, putting a fine in that particular clause, yes. Okay,
sir. Security of information. BOJ is suggesting that a new subparagraph 5 be inserted, which imposes an obligation on the authority to create policies and procedures to minimize the risk of breaches of the Cybercrimes Act. And they believe that the amendment would support subclause 9(8) of the bill and would provide additional comfort to members of the public about cyber risk management and obligations imposed on the authority. And we believe that this is already covered in the bill via Clause 5.5, which speaks to the obligations of the authority in this respect, as well as Clause 6.1h, which speaks to the board's obligation regarding enterprise risk management, which does include cyber risk management as well. With regard to disclosure of identity, the subclause at 24.5, the BOJ is indicating that they believe it should be clear which party is required to destroy the information, that is, whether or not the party in receipt of the information should be the one destroying it. And their interpretation of the clause is that it would appear that the party in receipt of the information has the obligation to destroy it. If the understanding is correct, for clarity, they are suggesting that we amend this clause to state specifically that the Commissioner of Police has the obligation to destroy the identity information that was disclosed pursuant to the court order. And we recognize and put for the consideration of the committee that there may be scope for further clarity as it relates to the disclosure process and the safeguards regarding same, including the responsibilities of duties and duty of care placed on the receiving party or parties, they need to observe upon receipt or treatment. Mm-hmm. So we're indicating that consideration may be given to this suggestion. And as it regards part 2 of the question, whether or not the Commissioner of Police should be required explicitly to destroy the identity information, we will refer to the drafter as to whether or not that is necessary for inclusion in this particular clause.
But could that be dealt with in regulations?
No, because that would be, if it is we're going to legislate on that, this would be something that would need to be in the bill. It's the primary legislation.
Okay.
The details of it would...
All right, make a note of that for us, please. All right, continue.
Right. BOJ was requesting that consideration be given to whether there should be a reference to all levels of appeal. And we believe that this amendment is unnecessary because the clause already contemplates the different levels of appeal, such that no action would be taken with regard to the destruction of that identity information until all levels of appeal have been exhausted.
Okay.
And the BOJ again suggested that for clarity, the subclause should state who should give the certificate of destruction to the individual. And we refer to our initial suggestion as it relates to clause 24.5. In clause 24.9, in the second line, should this refer to subclause 6 as well as 5? And this, we believe, is a question for the CPC. Yes.
No, the reference to 5 is correct because 6 is really an ancillary provision to 5. So 6 already refers to proceedings referred to in subsection 5.
Thank you, CPC. Clause 11, 2411, this provision presumes that the individual will be made aware or become aware. So in this clause, the Commissioner of Police may obtain an ex parte order, and accordingly, the BOJ believes that the provision presumes that the individual will be made aware or become aware that their information has not been destroyed, but the bill does not reflect any wording that suggests the notification to the enrolled individual. Again, this would be a question for the drafters because we believe civil procedure rules would be applicable in this instance.
Continue while
Thank you, Chair. Request for information. The BOJ is suggesting that the term accredited third party be defined, and we believe that the consideration may be given by the committee to this particular recommendation.
All right, make a note of that for consideration by the committee, okay?
Right. With regard to clause 25.5, the BOJ is indicating they're not certain how clause 25.1 would be complied with without disclosure of any identity information. And our response is that consideration may be given by the committee after the technical team revisited this clause, because we are proposing that the committee consider to amend the clause to indicate that only fingerprints will not be disclosed. And this change is required to eliminate the repetitive requests by third parties for an individual's identity information and the repetitive provision by an enrolled individual of their identity information to the third parties. Clause 27, for clarity, the BOJ is suggesting that consideration be given to amend the provision to include wording to indicate that essentially this is where the BOJ is not certain that the inspectorate will not be subject to the data protection regime and the Data Protection Act. And we believe that this is already provided for in clause 27.2, but reference again may be made to the drafter as to whether or not this is something that needs to be done. As it relates to the inspectorate identifying an issue with how the authority is operating, BOJ does not or is querying why can't the inspectorate also refer an identification of non-compliance to the appeal tribunal. And they indicate that the inspectorate can currently report issues to to the entities that are listed there, the DPP, etc. But it seems that NERA should have an opportunity for perceived breaches to be addressed by the tribunal initially. And our response is that the tribunal is not an appropriate body for these types of matters which are referred by the inspectorate, because the inspectorate is monitoring the authority, the appeal tribunal for a particular purpose. And if you look at the organizations that it may refer to, you'll see that they are of a particular nature, whereas the appeals tribunal is there for the enrolled individual as it relates to any decision that the authority has taken. So it's two different subject matters. In clause 28, we had dealt with that. Clause 29.3b, it is suggested that this provision is unclear and should be revisited, and this provision is speaking to the disclosure of information where...
We will have CPC to look at it and for further consideration. Okay? Go ahead.
Clause 32 was already before the committee.
Right, the committee
33,
will... Yes.
Right, 33.2 Right. It is suggested that the subsection should refer to the procedure for destruction of identity information where enrollment is cancelled, and we believe that consideration could be given to this suggestion.
Okay.
Clause 36.1, as it relates to the transitional, this is a drafting issue. It's noted that where the BOJ is indicating that the expression former department is only defined in this particular clause, and they believe that it should be included in section 2 of the bill.
Yes, so it's only using that provision, so it's convenient for reading for the definition to be included there rather in up in clause 2.
Right. So, Ms. McCullough, quite a number of the issues you raised were responded to. Some of them require further consideration by the committee, which normally at the end of these presentations we get a matrix, and the committee would then give it further consideration before a decision is made. So I want to thank you. The next presenter is the Jamaica Coalition for Health Society, but Mocha, I rather doubt we're going to reach you. So we're not saying you're to leave, you can stay. But I suspect once we finish with the Jamaica Coalition for a Healthy Society, we probably will take the break. And so you will be first next week Tuesday, okay? So I'll put you as number 1, but you don't have to leave, but I'm just intimating that it's not likely we'll take you this evening. So, Ms. Richards, I think you're present, sorry. Ms. Philippa Davis. Thanks, Ms. McCullough. You don't have to leave. You can go ahead, Lee.
Okay, thank you, Mr. Chairman, the members of the Joint Select Committee, the other presenters, parliamentary staff, others in the gallery. Good afternoon. The Jamaica Coalition for a Healthy Society, JCHS, welcomes the opportunity to present our comments on the draft National Identification and Registration Act. With me is Mrs. Shirley Richards. I'm Philippa Davies. The JCHS comments that it is commendable that the government is seeking to bring Jamaica into the digital age. This could certainly be of great benefit to the country, but depending on the approach taken, it can be a two-edged sword. Laws are not made in a vacuum. They're built on a philosophical framework. And two key questions the Jamaican public must ask itself are: 1, what philosophy is informing the NIDS legislation? And 2, is it for the benefit of the people or to facilitate government control of the people? An overarching concern for the JCHS is that Jamaican citizens...
Sorry? Was it circulated? We have a presentation from you which you say over...
Yes, Mr. Chairman, we did send our written comments.
No, just hold a second so we make sure members have that presentation. Right, this is one dated February the 23rd, where it says it overtakes their previous January the 29th presentation. That's the one you're moving for.
I am, Mr. Chairman.
Yes.
And my apologies, the members might be handed an extra page 1. Somehow when we PDF the document, the last sentence fell off the page, but we found it, and so we put it back on the first page, and so members would be given an extra page 1 that we would just ask them to attach with the main submissions.
Okay.
But it is essentially the same.
All right, go ahead then.
My apologies. Thank you, Mr. Chairman. So I was saying that an overarching concern for the JCHS is that Jamaican citizens must retain the freedom to participate in the economic and social activities of the country. The government has repeatedly stated that enrollment in the NIDS will be voluntary, not mandatory. Yet if enrollment becomes the basis for access to basic services that are currently available through the existing forms of national identification, or if access to enhanced and necessary services will not be available to non-NIDS card holders, enrollment will be a requirement in practice, if not de jure. The JCHS posits that in a free and democratic society, legitimate involvement of citizens in economic and social activities of the country must not be curtailed by the government. We therefore are of the view that citizens should not be excluded from economic and social activities if they do not want to participate in the NIDS. As such, if citizens do not wish to enroll in the NIDS, the other current government-issued IDs ought to remain in force and not be phased out. Concerning the Clause 5.2, the impact of the NIDS bill on the Registrar General's Department, RGD, it is proposed that the Registrar General be appointed by the NERA. It has been proposed that the Registrar General be appointed by the NERA, with the RGD being under the management and control of NERA. We are concerned as the remit of the RGD is different from the remit of the NERA. Is there a way of preserving the independence of the RGD while at the same time allowing for collaboration between the offices? The remit of the RGD is keeping of the civil status registers, whereas the NERA matches a name with a number and a photograph. We are advising against a merger of these activities to ensure the continued independence of the RGD. We note, too, that the Registration, Births and Deaths Act currently prohibits doing business on Sundays, Christmas Day, and Good Friday. This absolute prohibition will be replaced by the discretion of the NERA Registrar General to open in such manner and at such times as the Registrar General thinks appropriate. This is Clause 17.5 of Schedule 4 of the NIDS Bill. We take objection to this change. This is a country which still holds to certain Christian tenets, thus there should be no possibility of the RGD opening on Sundays, Good Fridays, or on Christmas Day. Jamaica is not a secular country. Our national anthem and pledge remind us of that. Even as we deal with a system of establishing a system for validating identities, we must not at the same time whittle away the country's national identity. The JCHS posits that a nation must have its own identity, otherwise, such a nation will have no defense against those who wish to refashion or redefine its identity. It leaves us to wonder whether this proposal provides a glimpse of where the NIDS intends to take us as a nation. Concerning Clause 5.4f on the powers of NERA, the NERA has been given the power to do anything or enter into any arrangement which, in the opinion of the authority, is necessary to ensure the proper performance of its functions. We consider this clause to be unnecessarily wide and thus capable of abuse. For example, could the information gathered under the NIDS be shared with foreign governments on a promise of funding to enable more efficient functioning? We recommend at the very least the insertion of the word lawful in this sentence. Clause 9.6 on amendments to identity information after enrollment. This clause allows for changes after enrollment on the basis that the information is incomplete, incorrect, misleading, or otherwise in need of updating. Could this clause be used to allow an individual who has changed his or her appearance to that of the opposite sex, or allowing a grown man who has taken on the appearance and behavior of a little girl to register their acquired or preferred identities? We are strongly urging the insertion of a proviso to state as follows: provided that no change in the sex recorded on the individual's birth certificate shall be permitted. Without such a clause, the NIDS could become a system based on genuine imagination, but not on reality. We in Jamaica cannot be complacent about safeguarding one's identity by sex, as we need to protect, for example, our sportswomen, because there have been cases from overseas where men changed their appearance to that of females and then entered women's races and won. For example, according to a May 2019 news article in the online sports site Let's Run, Craig Telfer, a Jamaican American, who was a mediocre 400 meters athlete in the male division, suddenly declared that he was a she and now wins races in the female division under the name CC Telfer. This is actually so. Another article in USA Today expresses a deep concern of athletes, coaches, and parents who have been watching in disbelief as girls are being replaced on the winner's podium by boys who self-identify as girls at all levels of competition. If we want to protect our girls and women in the field of local sports, then we must make it clear that change in the sex recorded at birth will not be allowed. Clause 11.1b1, definition of facial image. The clause states that the required biometric details include facial image. What are the anticipated uses of facial image? If the rationale of the legislation is to provide for a system of identification, why is it that more than a photograph is required? We do recall that Mr. Vernon, the program director, stated at a NIDS town hall meeting in January that facial image meant photograph. If it is so, we ask that the word photograph be used instead of the words facial image. Our concern is that facial recognition beyond the meaning of photograph carries the connotation of a surveillance state. Is that what the Jamaican people want? Clause 14.4. This clause states that the NERA may restore enrollment in certain circumstances. It's not clear why enrollment would be uncertain, meaning the use of may, if the authority is satisfied that accurate identification information has been provided. And so we recommend that the word shall be substituted for the word may in those circumstances. Clause 20, cancellation of the card. We note that the NERA may cancel the card in certain circumstances and thereafter inform the enrollee of the cancellation. Our recommendation is that NERA give notice of intention to cancel within a certain time period, for example, 30 days, and during that time allow for an appeal against that decision. Not only should notice be given, but also the grounds for the intended cancellation should be stated. We turn to the first schedule, clause 41b7, looking at the composition of the Board of Management of NERA. We noted that there is provision for appointment of a representative from a non-governmental organization concerned with human rights. This qualification is a rather narrow base from which to make a selection from among civil society groups. What makes this qualification of even greater concern is that there are no parameters given to judge which organizations will fit this description of an organization concerned with human rights. We strongly recommend a revision of this clause and that the qualification be widened. This clause could read, one member elected by a recognized local community group, church, citizens or service organization, or NGO. In the first schedule, clause 4.4, and the second schedule, clause 1.3, the duration of terms of office for members of the NERA board and the appeals tribunal. We note that there is no limitation to the number of terms for which a NERA board member may be eligible for reappointment, nor the members of the appeal tribunal. We recommend that a person be eligible for a total of 2 consecutive terms of 3 years each, so 6 years, and sitting out an intervening term before being re-eligible for a final 3 years term. The fourth schedule, clause 3, presents amendments to the Marriage Act, and we note that 5 amendments to the Marriage Act are being proposed, yet only 1 such amendment actually relates to the NIDS. The same applies to the amendment to the Matrimonial Clauses Act. What is the justification for this inclusion, or this proposal, we should say? We're concerned about inserting amendments to other pieces of legislation where such amendments are irrelevant to the focus of the primary legislation being debated. Further, we note that subclause 13.4, a proposed amendment to section 71 of the Marriage Act. Under the current section in the Marriage Act, the minister is allowed to vary the penalties under the Act. However, the new subsection being proposed, 71A, states that the minister may make regulations prescribing any matter required to be prescribed under this Act. However, no rationale or justification has been given for this proposal, neither does it bear any relationship to the NIDS. We therefore question, the inclusion or the proposal of this clause. Further, in a time when the definition of marriage is under threat in Western nations by worldviews or philosophies contrary to the philosophy on which Jamaican law is and has been based, we would strongly recommend to the Parliament that every care be taken in what is allowed as amendments to the Marriage Act and other connected pieces of legislation. Now looking at the fourth schedule, clause 17.6 and 7, section 55.1 and 2 of the Registration, Birth and Deaths Act. We query the proposal to delete which particulars are to be provided upon application for a certified copy of an entry in the registers of birth and death or in the civil status registers kept by the Registrar General. Currently, by virtue of sections 55.1 and 2 of the Registration, Births and Deaths Act, the certified copy of a certificate would show all particulars and or corrections to original entries, and for the birth certificate in particular, the name, surname, sex, and date and place of birth to be identified. The NIDS bill proposes to give the Registrar General discretion as to which details may be released, namely, such particulars of the entry as may be determined by the Registrar General. This proposal will place the Registrar General at the mercy of those who would rather for certain details, for example, sex, not to be included on a certified copy from a particular register. It is far better, we think, for the law to state, as it currently does, which details are to be included in a certified copy of a certificate. And we're therefore urging the Joint Select Committee to reject the proposal. On use of data, we note that there is no specific prohibition against the sale of data collected under the NIDS. The Data Protection Act is not yet in force, and even when in force, a data controller will be allowed 2 years after the date of enforcement within which to comply, and that is section 76.1 of the Data Protection Act. Some other concerns, Mr. Chairman: safeguarding other current forms of identification. We note that NERA can retain for such period as may be prescribed a record of each request for authentication or verification under the section 25.4. This period for retention has not been specified, which is cause for unease. In effect, it means that the authority will be in possession of data other than the basic identification details, at least for a period of time unknown, thus enabling electronic profiling. Not all citizens may want to be part of the system, particularly with the recent mishaps with the JAM COVID system. The mishap with JAM COVID data is an example of what can happen even with the best of intentions. This underscores our point that as a safeguard, persons should be allowed to rely on the current forms of identification if they desire so to do, as distinct from being required to enroll in the NIDS. We reiterate our primary statement that for the NIDS to be truly voluntary, citizens must in effect have the freedom to choose whether to enroll or not. If this is not done, then the government will simply, over time, use its forceful powers of persuasion to enforce the acceptance of the NIDS as the only acceptable form of identification. We therefore strongly recommend the inclusion of a clause as a safeguard stating to the effect that nothing in this Act shall affect other forms of identification issued under other legislation. We know that the projected implementation of NIDS will cost $1.33 billion. At such a high price tag, we urge the government to take the time now that our rights and freedoms will not be disturbed.
Where does this figure come from? I didn't know you have so much money, Mr. Vernon. Anyway, we'll continue.
One of the criteria for disqualification for appointment to the NERA board or to the National Databases Inspectorate or as a chief executive officer should be where the individual is under any acknowledgement of allegiance, obedience, or adherence to any other nation or state. These positions are so sensitive that no one who is a citizen of any other country should be allowed to serve in said positions. Mr. Chairman and the committee, having gone through the proposed NIDS Act, it is the conclusion of the JCHS that while it may not be the expressed current intention of the government to make enrollment mandatory, in the absence of provisions which would ensure that the other existing forms of identification continue to be equally accepted alongside the NIDS, this bill paves the way for mandatory registration. Mandatory registration with the attendant denial of participation in the economy will easily turn Jamaica from being a democracy into a totalitarian state. The JCHS thanks the Joint Select Committee for the opportunity to submit its initial comments on the draft legislation, and we look forward to further occasions to comment as the debate continues. Thank you, Mr. Chairman.
Thank you. I know members of the committee may have some comments, but did members of the committee get about where these circulated? This is in response, the NIDS response to the this is titled, submitted, joint, this is a response.
I don't have it. L. Harrison, I don't not.
But you didn't get this one?
No.
All right, while you circulate it, and circulate it also to the Jamaica Coalition for a Healthy Society, you have some comments, members, you would have some.
Chairman, just to say, the seemingly shy Minister of State in the Ministry of Finance and the Public Service wishes to answer your question in respect of the budget.
Chairman, you had raised some concern at the figure that was presented by the coalition. There's actually a JIS article which speaks to 1.33 billion being used to implement NIDS, and this was the proposed figure for 2019-2020. So I do believe that the figure is coming from there.
Is what?
From JIS. This is a figure coming from JIS as it related to NIDS for the 2019-2020 financial year.
I didn't know about it.
The answer is that the reference appears to be a correct reference with the source being the GOJ.
Okay. I just, no, may I just, members, while that is being circulated, may I just have one or two comments to the presentation, which I just heard. I must admit I haven't read it before. My first comment is that, to the best of my understanding, the NIDS bill is meant to assist the citizens of this country to access services as best as possible. It is voluntary, and to the extent that it is voluntary, the other cards can also be used. What I understand is that the NIDS Secretariat will hopefully, or the card itself will be so user-friendly generally that it will be used by the vast majority of Jamaican people, but it will not be enforced on them. The imputation or the imputation that the card is meant to ensure state control or to ensure the removal of democracy to a autocratic state. If I felt at any time that this was going to be, I can assure you that this Delroy Chuck would be opposed to it, okay? Ms. Richards known me for a long time. I believe in democracy. I don't believe in autocracy, okay? So to the extent that I felt that this is going to be a form of state control, I would be totally opposed to it. So from where I sit, and having read the bill and participate, I don't. Yes.
And for anything to do with government has to have one. So I think I think the concern expressed is that over time, more and more services may be tied to having to have a NIDS, and therefore, even though you call it voluntary, unless you're in the middle of the ocean, you just won't be able to survive without one. And I think that is more the concern than an upfront attempt to make it mandatory?
Well, sorry, yes, Minister, sorry, AG, then Minister Williams.
Chairman, I think while your personal position on the bill has been clearly and unequivocally stated, I am compelled to remind this committee of the Parliament that the intention of Parliament does not reside on the personal positions of parliamentarians, but that intention is reflected in the words actually used in the legislation, which are then interpreted by the court. So that I believe the submission by the Jamaica Coalition for Healthy Society has been carefully considered, and the issues have been even more carefully raised. And so, in the absence of some reference to the validity of existing forms of identification and the use of those identification in relation to accessing government's goods and services, then they have indicated that though presenting to be voluntary, it may end up with the unintended consequences of forcing and opting in. And to the extent that the legislation is truly intended to be voluntary, notwithstanding any of the many benefits to be derived, then some reference need to be expressly made to the use of existing forms of identification issued under law.
How would that make sense, AG? How could you in this legislation
I'm
say?
merely indicating what my understanding of the submission from the Jamaica Coalition of Healthy Society on the point is.
Why I ask that question? Because in the bill itself, this actually says that in putting together this card, it would use passport, driver's license, electoral registration card, this is number 12, to get the bill together, to get the card itself together. So to the extent that the card emerged from the use of all the other identification, then it seems to me that you're saying you have a card that has brought into play all the other forms of identification. So it is a more credible card than, say, one of the many cards that you have used. So that it is much more credible to use it or to be relied on than to say you use one of those that was used to put the card in place. So to say that, or to put in section 12, that notwithstanding that this card will come from these different cards, any of these cards will still be acceptable or be as valid as the NIDS card. I'm not too sure that would make sense, AG.
As I understand it, though, the point is a different point that you're responding to. So it's not so much the credibility or the superiority of a NIC when issued having regard to its uniqueness, but for persons who have not opted in, who would still be required to establish their identity, how will the existing forms be treated? But I think the coalition can clarify for itself. Just to say that I believe very sensitive issues have been raised by the coalition, which are issues that are live in different segments of the society. And so, for my part, let me express my appreciation for raising these very sensitive issues, some of which had been raised in the constitutional matter, but I know these are concerns that exist in parts of the society.
Thank you, Chairman, and thank you to the members, Attorney General and MP Robinson. And certainly, Mr. Chairman, to give that assurance in writing that the other forms of ID will continue to be valid and can be relied on, and that citizens have the freedom to choose whether to enroll for a NIC or not, then it would be important to have it reflected in the legislation that the other forms of ID continue to be valid and reliable by citizens in carrying out their various interactions.
Speaking for myself, I wouldn't support it.
Could I,
Sorry, Minister Williams.
Yes, Chairman, 2 points with regards to the one just mentioned about current IDs should continue to be reliable. I think, and maybe you can correct, we have an issue now with things like duplicate TRNs and so forth.
Driver's license, passports.
Yeah, and all of that. So I don't think that particular phrase could be codified in law, that the IDs are valid. I want to go to another point, though. In your presentation, you posited that in a free and democratic society, legitimate involvement of citizens in economic and social activities of the country must not be curtailed by the government. Totally agree with you on that, but I want to point out that currently many persons are not able to access government services, and I could give you a case in point. Right now, at the Ministry of Education, Youth and Information, we are trying to give to citizens 20,000 Jamaican dollars towards the purchase of a tablet or laptop, and I can tell you that this has been going on for well over 3 months now, and we're not even halfway towards our mark, because many persons that want to access it, the documents that they have, which would be their birth certificate, TRN, their name, those 3 things may not even match, and so you can't really authenticate who they are to be able to give them state benefit. In a time and space when we have this ID that is a strong national ID, many more citizens will be able to access benefits from the government than they are able to do right now. So I don't believe that, while I believe what you've posited, I don't see the needs as being any way, shape or form meant to exclude persons from the economy at all. Quite the opposite. It's meant to open up opportunities and government benefits where they are available to the citizens.
Yes, Member Bunting.
2 questions for Ms. Davis. The first one, regarding the guarantee of the voluntary nature of needs, in that you're not compelled to enroll. And further to what Mr. Julian Robinson said earlier, the amendment that you said that you proposed to the legislation, should it be worded, or in your opinion, would it be useful to word it in a way that says explicitly that there should be nothing that the citizen is prohibited from doing by their not having a needs card? That's the first question. Secondly, would you be in favor of, instead of starting a brand new registration from scratch, in using the passport office or the passport as the second division, the passport agency, PICA, as the second division of NERA, Registrar General being the civil registrar, and the passport section would be replace what is now proposed to create a whole new administrative bureaucracy at great expense to taxpayers,
and a long enrollment process, whereas I think it was the Chief Justice who had suggested that why not just offer everybody a free passport, and I think you'd probably get a much higher enrollment than you will get with NIDS. So could you respond to those two questions for me?
Thank you very much to the members for their question and comment. If I may just respond, in the absence, though, of Minister Williams, that if there is the challenge of matching identification documents now, would that not also arise when these documents have to be fed into the creation or the issuing of the NIC? And if they are going to be resolved or can be resolved at the time of issuing a NIC, then can they not be resolved even at this stage? Why would the mismatch at this point prevent persons from relying on those pieces of identification separate from a NIC? And to MP Bunting, yes, that language that you suggested about not being prohibited would assist. So thank you for that suggestion. And I'll let Mrs. Richards respond to the other question.
Through the chair to Member Bunting. You know, sir, we, in our first submission, we actually had that. It's going to cost 1.33 billion just for implementation. Wouldn't it be better spent on helping people who do not have birth certificates? Because we know there are still people in this society who do not have birth certificates and also passports. You know, that was the idea which came to mind. But we also realized that for some in the society, that there would be some in the society who would want to take advantage of the digital nature of this proposed identification, which would be the benefit over and above existing forms of the current existing forms of identification.
No, but your assumption is that we won't have a digital passport very shortly. I'm assuming that all these passports will be digital within a few years. So I think by the time we rolled out NIDS in any universal or near universal way, we would long have transitioned to digital passports anyway. That's where the world is going.
Thank you, Member Bunting. That would then resolve our concern, because we are aware that some, and maybe the financial institutions mostly, would want to take advantage of the digital age in which we are in. So if a digital passport would do that, then hurrah. I mean, we certainly would in fact go for that, you know. Right. So thank you, sir. May I just say, though, in terms of what we see as the creeping mandatory nature of the legislation, one thing we didn't mention is the proposed amendment to the Revenue Administration Act, and that's in the 4th schedule, whereby the registration authority under the Revenue Administration Act can, in fact, assign the NIN as the registration number to be assigned to the taxpayer for the purposes of the legislation. If that actually happens, that the TAJ assigns the NIN, then there we go. It will no longer, in effect, the whole thing will be mandatory. And as I said, the problem is that there might be some in this society who would rather not participate in the system. So we are asking that provision be allowed for those persons who would rather not participate in this system. Ms. Davis, part of the presentation, we noted that this is more than an identification. Part of it, there will be collection of data subsequent to the enrollment. And unfortunately, the legislation doesn't even say for how long that data will be kept. by the authority. I think that's section 25.4. It doesn't even say for how long. So there'll be collection of data even after the enrollment. And so people, there are some who have reservations about being involved in a system which is more than an identification, which will facilitate a system which in fact will facilitate some sort of profiling, digital profiling. Of course, what happened with Jam COVID certainly does not assist with building confidence in this type of system. So we're asking that provision be allowed for persons who would rather not be involved in the needs. But to the extent that they are not kept away from the different benefits in the society. Yes?
Just which part of the law points to your conclusion that the system is more than identification? What part of the bill you're referring to?
I'm referring to section 25.4 through the chair.
Yeah.
Section 25.4. It basically states that the NERA can retain for such period as may be prescribed a record of each request for authentication or verification under this section.
No, but Ms. Richards, this is just where a third party or second party just asks for verification, you know.
Indeed, sir, but this is
it's not additional information. It's like where the bank asks for verification of an ID. Is not my understanding. So it's not a question. It's nothing more than verification that the ID has been issued by the NERA.
Chairman, it is there because the individual has a right to receive a record from the authority of authentication.
Right. So to the extent that when
so they have to keep it.
Right. When any institution or person asks for information, the NERA must keep it so that in a year time or 2 years time, the individual asks, who asked for verification? The NERA can say, well, Bank X, Bank Y, Bank Z, at least 10 banks asked for your verification.
Furthermore, Chairman, it's not an indefinite period because the scheme of the request for information is the form will be prescribed, the manner will be prescribed, and the time frame will also be prescribed. So I'm just seeking to understand what in the law, because this doesn't answer that question if this is what you were seeking to rely on. That would cause you to so conclude.
I don't like for meetings to go on forever. What we're going to do, Ms. Davis and Ms. Richards, a response has been provided by the NID Secretariat. If you have any concerns with the response, we'll give you some time to respond to it, say next Tuesday. If you have no concern with the response, then you can so indicate to us. But when we meet next Tuesday, based on the response that has been provided by the NID Secretariat, we'll, if you so ask, we'll give you some time to respond, okay? Is that okay?
Okay,
because
thank you, Mr.
we really
Chair.
don't want to go through everything right now.
Right.
So, because we would like, I don't like to have my members here sitting forever, right? So if that is so, what
Mr.
we're
Chairman,
going to... Yes.
If I could just briefly respond to Minister Williams, since she was out
Sure.
of the room when I had responded, when you raised the question of the challenges of matching the current IDs and the challenge that presents when you want to verify the applicants for the tablets. But I'm assuming that there would have to be some resolution in order to verify who has applied and that you would release the item to someone who you are secure this is the person, the identities match. But such a mismatch would also arise if those forms of ID are the source or feed into the creating of the NIC. And so a resolution would be necessary at some point. Why then not resolve the IDs separate from the NIC? Because they would have to be, you would have to be assured that these forms of ID are accurate and reflect the person who is attached to those IDs.
Okay, as I said, we want to make sure everything is open and clear. So if you have some concerns, further concerns, we'll take you for a brief while, and then we take Mocha immediately after. Thanks, Mocha, for being with us. You will be almost at the beginning, depending on what happens. Sorry, Minister Williams.
No, just a response then. You know, the NIDS ID is a way of ensuring that we do have a national ID that is, you know, can authenticate persons, and it would be dealing with that very problem that we just brought up in terms of just the difficulties of linking all these different pieces of information.
You know, I just want to add, to bear in mind, to say that we must use some other form of ID. The vast majority of Jamaicans don't have a passport, a driver's license, and quite a number of them don't participate in the electoral process. So that, as Minister Williams has said, the greatest difficulty now is to ensure who has an ID. And most of the government IDs, vast numbers of Jamaicans don't have. That is why this particular ID is geared towards a man who can't drive, a man who doesn't want to travel, a man who doesn't want to vote. So, you know, so how does he have an ID? And that is what this national ID is about, to assist those who don't want to participate in the other government agencies to at least have an opportunity for an ID. I hope you see that point, okay? All right, but if anything, we can continue next week. Thanks now. Can we have a motion for adjournment? So move, seconded.
Mr. Chairman, I was just wondering if there's not a more efficient way we can have these hearings. At the rate we're going, it's going to take a very long time. I was wondering if the submissions, I appreciate how the submissions were done today, where the technical responses from the NIDS team were put there. I think that saves time. But when the presenters come and they still have to go over everything, I think it would be better if there was some agreed, these issues have been resolved, these issues have been addressed, we're now comfortable. Here's the balance of the unresolved issues, and so we just go straight to those.
I think you're right. I mean, on reflection, I must admit, Ms. McCullough's thing were quite, you know, inquisitorial. So that's why I said it makes sense to just respond to them. But if we are going to repeat those points again, it wouldn't make sense. Yeah. So what we are going to say, Mr. Vernon, if when we look at future, like say Mocha, I mean, I haven't seen Mocha's presentation or the TAJ or so on, could we shortchange them? In other words, you put them and said, dealt with in the response to BOJ or so on, and we just indicate to the committee it was dealt with in response to BOJ, and we don't mind giving the MOCA team or the TAJ or whoever a copy of where it was responded to. So, because otherwise, if we go through the same, as you are quite right, Member Bunting, so to the extent that when we look and say the MOCA presentation, let us assume they raise the same points as BOJ have. We just give them a copy of the BOJ and say these were dealt with, or this is a slight different response. And then you just say to the committee after the presentation, as you can see, these were dealt with in a previous round of discussions, okay? Otherwise, as Minister Bunting said, we could be here till December. So thanks to Member Montin for that position. Okay, thanks again, everyone. I thought it was a good afternoon. Okay, good. So moved. Meeting adjourned until next Tuesday at 2:00.
She want a lover man. Woman want good love. Now sympathize. Woman want good love every night. Right now. Love a girl.